Thompson,
Occupation?
Deputy Sheriff, Salt Lake County,
How long?
about 14 years.
Directing your attention to August 16, 1975. On or about that day, did you have occasion to know one Theodore Robert Bundy?
Yes, sir.
Did you know him prior to that?
No, sir.
Did you know at that time, and do you know at this time, what his occupation was at that date?
Yes, I did.
What was that?
He was a law student at the University of Utah.
You know what his occupation was in 1974?
I believe it was a law student also.
That's all I have.
Bundy?
Detective Thompson, you say you knew Theodore Robert Bundy on August the 16th, 1975?
Around that time, I was acquainted with it, yes, sir.
Around that time?
Yes.
On that date? You say for
I'm
sure?
not positive on the date.
Well, you give the benefit of your best estimate as to when you first...
The first conversation that I had with you was August the 21st, outside the Salt Lake County Jail. That I'm positive.
Did you ever met me prior to that?
No, sir.
No.
That's all. Thank you.
May this officer be excused?
Yes, sir.
I think you free to go.
That's all I have on the motion, Judge.
Do you have witnesses on the motion?
Yes, Your Honor. Mr. Harvey would like a couple minutes to confer with me before I take the stand.
We'll take a 5-minute recess, and you may confer with your counsel as we talk to you.
Everybody remain seated. The judge is out of the courtroom. We'll be in recess for 5 minutes. That's why I went to come and got you.
Yeah, that's one-on-one.
You tell him what you want. Now,
I just want to blow it out of the shop.
That's a lot more.
There you go.
Is that better? Mr. Bundy?
Limited purpose of this hearing,
On the motion only, I understand.
Raise your right hand, please. Do you solemnly swear that the testimony you will give the truth, whole truth, and nothing but the truth, so help you God?
I do.
would you please state your full name for the record? Stipulate that it's Theodore Bundy.
Theodore Robert Bundy.
Directing your attention to the early morning of August 15th, 1975, after you'd been stopped by Trooper Hayward, approximately what time of the
Did we
morning?
establish that was really the 16th, or did we? That date?
Judge, there's a discrepancy in the report.
Well, it's either the 15th or the 16th. Is there any question about that?
It's not.
All right. As long as we're not hung with one on one day and one on another, that's the only thing the court was worried about. We're talking about one single incident, either August the 15th or August the 16th. Is that correct, gentlemen?
That's correct.
All right. Proceed on.
About what time was
was early in the morning, approximately 2 o'clock.
After you had been stopped, did Officer Hayward say anything to you?
Well, after the stop had occurred, I exited my car, and the officer, Hayward, had left his car and approached me, and the first thing he said to me was, "Why didn't you get out of your car and run? I could have taken your head off," or words to those effect. Words to that effect.
Did he ask you for your driver's license and registration?
He did. I think he asked me a number of questions which intervened the request for a driver's license, and I think he asked me after his first comment what I was doing in his neighborhood, to which I did not initially make a response. And then he asked me for my driver's license, which I got from the inside of my car.
Did you produce a driver's license?
Yes.
Did you produce a registration?
Yes.
Did Officer Hayward advise you of your rights at that time?
No.
Could you relate to me the circumstances which took place immediately after you were stopped?
After I gave the officer my driver's license, he went back to his vehicle, as I recall, and leaned in and pulled out the microphone that they use for the radios and came back to me and told me to go stand by his car, which was approximately 10 feet in back of my car. He told me to wait there, and there was an officer, another state patrolman, who was already on the scene, and he told me to stay with the officer. He told the officer to keep an eye on me.
Let me back up a little bit. Was Officer Hayward in uniform?
Yes, he was.
Was he carrying a weapon?
Yes, he was.
Was the additional officer who had come to the scene, was he in uniform?
Yes.
Was he carrying a weapon?
Yes.
How many officers arrived at the scene?
Well, they arrived and they left. I'd say that at any one time, there were, at the most that were on the scene at any one time, approximately a half a dozen.
Was they all in uniform?
All except for Detective Ondrak, who arrived later, who was in plain clothes.
What was the attitude of the officers towards you?
Well, I testified as to Sergeant Hayward's initial reaction. After he told me to stand by his car, he proceeded to my car and he began to walk around it, shining his flashlight through the windows and peering in through the windows. The officer that I was standing with next to the patrol car began asking me questions, asking me what I was doing in the neighborhood, why I was there, so on and so forth.
Did any of the officers read you any rights, advised you of the right to remain silent at that time?
No.
Did anybody advise you of the right to have an attorney present if any questions take place?
No.
Anybody advise you that you had the right not to talk to them?
No.
All right, and then Officer Hayward was looking in the car with a flashlight?
Yes.
And then what happened next?
He walked, as I was standing by the car, watching him and listening to the officer next to me ask me questions. I watched him walk around the car and shine his flashlight in the car. He apparently was focusing on something inside the car for some time, or it seemed like some time. He opened the car door, entered the car, and I couldn't see what he was doing. He came back to me and then repeated his earlier questions about what I was doing in his neighborhood, why I was there, and then, as I recall, he went to make another call on his police radio.
Did Officer Hayward or any other officer at the scene ask you for permission to search the car?
No.
Did you give anyone permission to search the car?
No.
Had you ever been arrested before?
No.
Did anyone tell you that you had a right to refuse to let them search your car?
No.
Do you remember the words being asked to you whether or not you minded if they looked inside your car?
I can't recall a request to search my car, and the words, whether or not they asked me if they could look in my car, is something I don't recall or construed as a request to search my car.
Do you remember telling any of the officers that they could look in your car?
No.
At any point during this incident, did anyone read you your Miranda rights or tell you your rights?
Yes.
At what point was that?
After Sergeant Hayward had searched my car and called in another officer to come in, and after my car had been thoroughly searched by the other officers, Detective Ondracht approached me at that time and informed me that he was going to seize certain items from my car, and told me that he was going to attempt to get a warrant or a complaint or something of that type against me for possession of burglary tools. At that point, Sergeant Hayward or another officer, I'm not sure, searched me for the first time, handcuffed me, put me in his vehicle, read me the rights off a little card he carried on his console, and drove me downtown to the Salt Lake County Jail.
It was after the search had taken place
Yes,
and after the items had been seized.
yes.
Did you try to stop the search?
No.
Why is that?
Well, I'd say I was afraid to, but that's not exactly the way. I mean, it's not that I was quaking in my shoes. I felt that I couldn't stop them from doing what they were doing, that they were going to go ahead and do it no matter what I did. They were intent. The questions from Sergeant Ondracht and, Sergeant Hayward and the other officers at the scene indicated that they believed that I was involved in some sort of activity, and they were hostile about it. The questions seemed hostile to me, indicated to me that they were going to do damn well what they pleased, and I did not.
You didn't see any point?
There was no point. I didn't see how the heck I could stop a half a dozen uniformed armed officers from searching my car.
They didn't ask you for your consent?
No.
Objection too broad.
Let me ask you to see if you object to it. Do you have anything else?
I think that about covers it.
I have no further questions.
Mr. McKeever?
Thank you, Judge. Just a couple of things. That's not the first thing you told Hayward, though, when he asked you what you were doing in the neighborhood, did he?
What? Excuse me?
He asked you what you were doing in the neighborhood, and you didn't tell him right off what you were doing in the neighborhood, did you?
I told him what, I responded to his question.
I understand. What was that response?
As I recall, the response, I don't know when it occurred, was that I had been in the neighborhood to drive and movie.
Good one.
I said, my response to him was that I had been in the vicinity at a drive-in movie.
And you told him the name of that movie, didn't you?
Yes, I did.
But you hadn't been to that movie, had you?
Your Honor, I object. I don't think this is relevant.
I'm going to let him answer.
I don't think it's material to the issue.
Well, the question credibility is always material, and these are questions that the court would be concerned with. I'll let him answer.
No, I hadn't.
Well, you started off with a lie to him. And you followed that up. Let me see if I understand your testimony correctly. You followed that up with another story, didn't you?
You know, I object.
But restate the question.
Well, did you tell Hayward anything else after you told him that you'd been at the drive-in movie? You do recall your testimony during the courtroom proceedings in Utah, do you not?
I'm not sure what you're referring to. I think really, it's a broad question. If you try to be more specific, I can help you out.
Do you recall your testimony in Utah?
I recall testifying in Utah.
Do you recall the drive-in movie story you told Hayward? You've already testified to that.
Yes, sir.
Do you recall the marijuana story?
Your Honor, I object. Again, let's do it.
I'm going to rule it, there's some reference to it in the opinion.
Judge, excuse me for that hasn't been talked about by either the officers at this hearing or by testimony of the...
He's on cross-examination and the defendant. We got a direct pinpointed question of issue of fact that the court has to. And that's, I think, a valid question. Overruled, you may proceed.
Do you need me to freshen up your memory a little bit, Mr. Bundy?
I think if you could ask me the question again, I'm not sure what you're asking, but I can try.
I'm asking you kind of an initial question, and I don't mean to be confusing. Do you recall your testimony in Utah? If you don't, say so, and I'll try to refresh you.
Well, if you could give me a specific question, I don't think it would be difficult for me to sit here and quote you verbatim what my testimony was in Utah.
I understand. I can appreciate that. Let me see if this refreshes your memory. You recall testifying that on the evening in question you were eating dinner and watching television until 12 midnight or 12:30, which time you decided to visit a friend. That upon arriving at that friend's house, you noticed the lights were out, you decided not to waken her up, and you proceeded to drive around for a while. You ended up in the Granger area where you decided to smoke some dope.
Your Honor, excuse me, but if he's going to ask me a question, I will object to the summarization of the entire line of questioning. He's going to ask me a question.
Well, if I've sufficiently refreshed your memory, say so, and I'll stop. You want to tell us about that testimony?
Do you recall that, Mr.?
Do I recall the testimony?
You apparently do. You just told the court there was lengthy questions and answers about that point.
All I'm saying is that I don't recall the testimony specifically, but I can say that in general that I can associate what you're saying with the trial in Utah.
Okay. Specifically, do you recall telling the court in Utah that you fled from the officer in order to get the smoke out of your car and that you threw the marijuana out the window during the chase?
Yes.
Now, back to this case. Isn't it a fact that you've done all of the research on this particular motion?
Yes, such as it is. Yes, I have.
Have you found some cases on the point?
I found too many cases.
And the point we're talking about is consent to search, isn't it?
That's one of the points we're talking about.
Are you familiar with what the factual basis would need to be for a consent search to be thrown out?
Yes, I'm familiar with it. I am now. I wasn't then.
That hasn't colored your testimony a bit.
I think you'll find, well, no, it hasn't. And I think you'll find, if you review my testimony in suppression hearing in Utah, that it's essentially the same.
That's all I have, Judge.
And where you at? Do you have anything further, Mr. Bundy?
No, sir, I don't.
You may step down. Any further testimony on the motion?
I feel like I need to call Officer Hayward just briefly, Judge.
All right. Officer Hayward, then. Sergeant, I guess he is now.
Your Honor, then you need to re-swear this witness.
No, sir.
Step out of the witness stand, sir, and be seated.
You previously sworn, Sergeant. The oath is still applicable. You may proceed, Mr.
Thank you, Judge. Sergeant, are you familiar with the smell, the odor of marijuana?
Yes, sir.
How long have you had some experience in this odor?
I had 3 years, just prior to this date, of alcohol and drug enforcement, drug drivers in the state of Utah.
During the time you were in Mr. Bundy's car on this particular evening, at any time did you smell the odor of marijuana?
No, sir, I did not.
At any point during your search in the car or around the car, trunk, engine, whatever, did you find any substance that resembled marijuana?
No, I did not.
At any time during your chase of Mr. Bundy, did you see anything thrown out of the car?
No, I did not.
That's all I have.
And redirect? Or cross, excuse me?
Your Honor, we approach the bench.
Yes, sir.
I have no recross on this witness. Cross, I misled. Cross on the Bible. But one matter that I neglected, just procedural matter, it's technical. His report into evidence for use here. His police report. That's it.
I don't care, no problem. That's still.
I have another report here.
You marked his report on your,
We've marked the report, this one. This is,
Just asking if that's the full report, if it's accurate.
Sergeant Hayward, I'm showing you a document list marked as defendants proposed exhibit A1 identification. I ask you to identify that, please.
It appears to be
Appears to be what?
the same document I have here, full document.
Your incident report of the stop that occurred on August the 16th, 1978?
Yes.
We'd offer this in the evidence.
be received without objection, out of order.
Objection.
Defendants exhibit A on the motion to suppress standard evidence.
That's all I have.
Sergeant Hayward now be excused.
Yes, sir.
Let you free to do so. Defense have anything further on the motion?
Nothing further, Your Honor.
State have any other rebuttal?
No, sir.
Motion's closed. And gentlemen, I'm going to take argument on both of the motions to suppress. In either procedure that you want to go by, you may take the state, would argue first. Go ahead.
Judge, may I ask, motion to suppress what now? Is this motion to suppress Nina Neary's testimony also?
Yes, sir.
All right, I'm gonna have to gather my troops.
Are you prepared to argue on this one first then?
Your Honor, I'm not prepared to argue the law beyond generalities. I have a great deal of case material As I say, I have not had access to the library to streamline it, as it were. I would be willing to make a general argument, but would reserve the right to submit to the court a memorandum of...
All right, I'm gonna rule on both of them till in the morning anyway. I want to hear the argument on both of them this afternoon. There's no more hearing testimony. How about Picano and...
As I
Do
understand,
that during trial if you want to, Judge.
I thought we had reserved that for during the trial. Now, this is all the testimony to be taken on a motion.
yes, sir.
No,
The
sir,
rest
we have some statement testimony that you need to hear and some more Williams rule.
Well, we've got some William Rule questions, but they primarily will be not witness testimony, as I understand.
You do have some short testimony.
All right. Well, let's take these two motions to suppress in that order. Are there argument on them now, and then we'll...
Judge, we give you a chance to get Mr. Haggard?
Yes, I think you should, and we're going to proceed now with the argument on the Granger, and Mr. Bundy, you may proceed.
Your Honor, there's a lot of cases in that box, and they all deal with consent search issues.
Yes, sir, I'm sure that there's probably that many more that you've missed.
And I've missed quite a few. We're only dealing with a couple jurisdictions. As I said, I'm going to argue the law broadly because I haven't had an opportunity to complete my research on the status of Florida law, although I'm familiar with the parameters of the consent search issue as they exist here in Florida and those as outlined by the United States Supreme Court and other federal courts.
Well, we really basically set the stage. I'm sure you've read Bustamante.
Yes, sir.
Let's proceed with that, and we'll go from there. And you're not going to be far wrong from Florida law.
Well, I think before I refer to the Bustamante case, I think it's important that the court be put in a position of determining whether it's Florida law that applies or the law of the state where the search occurred. And of course, I would argue that from the integrity of this court and the integrities of the court of Florida, that the conflict should be resolved and in the manner of adopting the law of the forum state of Florida to determine whether a consent in the search that we've heard testimony in today was freely, voluntarily, and knowingly given.
Well, you've got more of a basic threshold argument as far as that is concerned. This court would have to take into consideration the rulings of the Supreme Court of Utah, Mr. Bundy, as far as the concept is concerned. And the only collateral attack, or something in the nature of a collateral attack, would be a federal argument. As this court conceives the law, I think the state of Utah has ruled on it, and it is provision of the Constitution that you're well aware of concerning full faith and credit and the finality of the arguments as it relates to seizure of the goods under the forum of where they're seized. This court would consider that the only possible collateral approach would be on the basis of some additional federal requirement, maybe not brought to the attention of the Utah court. However, so that the record is patently clear, I'm going to proceed with the concept that both arguments, or all three arguments, are in fact open. And I'm not going to close you out on that. Brevity has never been the keynote of this trial and probably never will be. So I'll hear whatever you have to say.
Well, I think, and I will do my best to acquaint the court with issues that are directly involved in the search, which did not come to the attention, or I would tell the court that these issues did not come to the attention of the Florida Supreme Court, the Utah Supreme Court. However, I understand that the court has read the Supreme Court opinion, the Utah Supreme Court opinion, and will simply direct the court's attention to the findings of Chief Justice Ellett. And Chief Justice Ellett did not find that the search ruled on by the trial court was legal. The legal finding of Chief Justice Ellett in State v. Bundy was that there was evidence sufficient to justify the judgment of the court. It does not speak to the standards of law in Utah or anywhere else as applied to search and seizure, and the search and seizure issue involved in the Utah case. I think what we have here is simply a badly written opinion, and one which is self-evident, relies on virtually no case law, and a very highly complicated appeal. And so I will say only that I don't believe reading of the Supreme Court opinion is dispositive or in any way persuasive in determining the legality or illegality of the search that occurred, and it's the subject of this motion. And let me go to the Bustamante case because it's so often referred to and because it's so important in consent search cases. And I think that this court must first recognize that in the Bustamante case, the United States Supreme Court narrowly decided the issues before it and concluded that its ruling on whether an advisement was necessary.
She has one. I know. Where is the lady?
Pardon?
Where is the lady?
Where's Mrs. Mary?
She's right across the hall.
Does she have photographs with her or clippings with
I
her?
don't know. You'll have to ask her. She might have them in her purse.
You want to let this young lady step down from the stand and bring her over? If they're of some benefit to us, if you can get them for us, Mr. Simpson,
All I was going to suggest is we've already given them copies of them. They can use the copies of the relevant originals.
whichever one you have.
Our copies are poor, Your Honor, but
Well, why don't you ask the lady to bring them over? We're not before the jury, and the court could glean something from them, maybe. Would you extemporarily excuse this lady for the rule and let her sit here and identify the public? Bring Mrs. Neary over. Lady, if you'll step down and sit right there, it'd be fine.
Come right over here, please, ma'am. Step up in the witness box, please, and raise your right hand.
And do you solemnly swear that the testimony you will be the truth, whole truth, and nothing but the truth, so help you God?
Be seated.
Mrs. Neary, would you state your full name for the record, please?
Wanda Neary.
All right. And you're the mother of Nita Neary?
I am.
Do you have some newspaper clippings that you collected
I
with
do.
respect to this case?
I do.
All right. Do you have them with you, ma'am?
Yes, I do.
All right. May we see them? Be put together somehow. Could attach it this way if you want.
Just Haggard, you're only interested in the ones that show Mr. Bundy.
Yes, John.
Not
That'd be
concerned
fine.
with the other details.
Other than to show reading content, Your Honor.
Return all to the lady that you can. If we need to make photostats for them for the record, we'll give them. I don't want to confiscate it.
Yeah, the one I'm returning is Sunday, January 22nd, 1978, the Indianapolis Star, page 10, section 3. Caption on it is Tallahassee Terror, Police Lack Clues to Killing.
We'll see that you get the others with substitute photographs for them later.
Could we have this one just photocopied for the record?
Yes, we can.
All right,
We
I
certainly
don't
can.
need it in as an exhibit. That's fine. Yes, Mark.
We'll photostat and substitute the photostat for the original and return the original to Ms. Neary.
Ms. Neary, while clerk is marking the other exhibits, I'll ask you and show you what has been marked Defendant's Exhibit A1 for identification, and ask you if you recognize this newspaper clipping.
Yes.
And did you cut this out of the Sentinel Star?
No, I did not.
Who cut this out of the paper?
I don't know.
Did you
Ms.
show?
Neary, you're shaking. Don't be upset here. Relax.
Did you?
There's no reason to go through all the press, and we'll stipulate these and have.
Did you show this to your daughter Nita?
The daughter would probably be the best answer to that, wouldn't it, Mr. Haggard?
I think so, yeah.
I don't think we need to. Everything's all right, Mother. Relax, all right? Take
Thank
care
you.
of yourself. All right. You may step down.
Thank you, Ms. Neary.
Young lady, please take the witness stand.
Ms. Neary, I show you what's been marked. Defendant's Exhibits 1, 2, and 3 for identification, and ask if you can, A1, 2, and 3, ask if you can identify them as having seen them before.
This one, no, I do not remember seeing it before.
Which one is that, Mr. Haggard?
Number A1.
All right.
Let me see.
This one, yes. This is the series I was talking about where each one looks different.
What number is that?
A2. And A3?
I don't remember. It's looks like the same series there. I might have seen it. I don't really remember. But I might have seen this one, but it's the same pictures as this.
Did your mother have any other pictures than these?
I don't know.
Well, how long has your mother had these pictures?
She's had them for a while, for when the paper started coming out, but she kept them in an envelope, and after I had seen the series of 6, I was advised not to look at any more pictures in the newspaper or on television, and so I stayed away from them.
You've identified A2 as the 6 you saw.
Yes.
Well, that was prior, A2 was prior to you being advised or after?
Yes, prior.
What is the date of that, Mr. Haggard?
February 19th, Your Honor.
All right.
Did Did you see all of the clippings that your mother collected?
No, I did not.
Did you see these that she brought here today?
She's already.
I already-
I'll sustain that. She's answered. Now, if she's seen any other, I'll let you inquire.
Did you see any in this one that had sort of a profile?
No.
Excuse me. Did you see any in, and that was A2, did you see any in A3 that had sort of a profile?
No.
Do you recall telling Detective Bodiford that you had seen sort of a profile on March 14th?
Objection, Cadillac, Predator.
Later, Predator.
You recall this question by Mr. Bodiford? Did you recognize him? Answer, I can't guarantee you I didn't see a good profile, but she just showed me a picture, she referring to your mother, about 2 days ago of a sort of profile. Recall that?
Vaguely.
Was this the sort of profile that your mother was referring, or you were referring to on the phone?
I don't remember that picture right now.
It was in your mother's possession, was it not?
Objection.
No, that's no test of her recollection. What is the date of that?
The date, Your Honor, is 2 days after Exhibit
Well,
A2
never mind
there.
what A2 and that, what's the date of that?
February 23rd.
Thank you, sir.
You recall your conversation? And Your Honor, so I can refer to the one I referred to as sort of a profile as A1 for the record. You recall your conversation with Detective Bodiford?
Yes, I remember talking to him.
What did he tell you about having someone in jail down in Tallahassee?
Objection.
Find out what you recall from the conversation first. Don't lead her through this.
What do you recall about the conversation, ma'am?
The main thing, the main point I remember about the whole conversation was, don't look at any more clippings.
Did he tell you why not to look at any more clippings?
So I could have a positive identification and that the newspapers wouldn't sway my decision.
Did he use the specific word taint?
Pardon me?
Did he use the word, so do not look at any more newspapers so it wouldn't taint your identification?
I don't remember.
Do you know whether he discussed that with your mother?
Objection.
Sustained.
Did your mother tell you not to look at any more pictures in the newspaper because Detective Bodiford had told her that?
Objection.
Sustained.
Do you remember your mother showing you any newspaper photographs in the car?
Vaguely, yes.
And she pulled out an envelope?
No, I don't remember the envelope.
Where were you driving to?
I believe we were going home. We were downtown Aurora somewhere, and we were driving home.
Did you say to her that it looked like the nose, but it was still not a good profile?
Objection.
Sustained.
Did you make a comment as to whether or not it was a good profile to your mother?
I remember.
Your Honor, that assumes that she said there was something like that.
I'm asking if she made...
There's no establishment that it's taken place, Mr. Haggard. That's the problem.
You were in the car, and your mother showed you some photographs, right, Ms. Neary?
Yes. A photograph.
A photograph.
A clipping. I don't remember which one it was.
A photograph.
No, Your Honor, that's
It's
probably...
a photograph or a clipping.
A clipping.
All right. Was it a clipping with a photograph on it?
Yes.
And was it a partial profile?
I don't remember the picture. I'm sorry. I don't remember.
Do you recall making any comments about the nose?
No, not specifically the nose.
Do you recall making any comments about whether or not it was a good profile?
No, I don't remember. I remember, what I do remember is glancing at it, and I was tired of it, and I just said, I don't want to see anymore. I don't want to make any judgments.
Do you recall saying anything to Detective Bodiford about any resemblance of the newspaper photographs to the man going out the door?
Objection, please.
There. She's already established she remembers the conversation. I'll let him answer the question.
I answered.
Yes, ma'am.
Could you repeat that, please?
Yes. Do you recall making any comments to Detective Bodiford about whether the newspaper photographs resembled the man going out the door?
No, I'm sorry. I don't remember.
Do you recall saying that you could not promise that you could make an identification to Detective Bodiford?
No, I don't remember.
Let me ask you if you recall this statement and this reply with Detective Bodiford. Detective Bodiford, do you think that you might be able to pick it out? Your reply was, I can't promise anything, but I, ... Do you recall that statement and reply?
No, I don't remember.
And continuing by Mr. Bodiford, what about if you were to see a live lineup? And your reply, well, again, I can't promise anything, but it could, ... Do you recall that?
No.
Pardon?
No.
And your reply again, you know, I hate to promise anything I can't, you know. Do you recall that?
Some of these statements just being taken out of context, I'm not sure what it's going to file.
If they're read out of context, make your objection timely. I don't have a copy of the document he's reading from, Mr. Simpson.
Do you recall discussing with Detective Bodiford a partial profile from the newspaper?
Objection.
Sustained. We've been through that.
Do you recall this statement by Detective Bodiford in this reply? Right, but so far the pictures you've seen, you haven't counted him at least? Yeah, but the one when we had his nose turned a little bit did the best for me, you know. Resembled more than any of the other ones. But the other ones were hard to tell because they had like 6 different pictures of him, all different, you know. Do you recall that discussion?
No.
Your Honor, Mr. Harvey says my secretary called and there was some emergency in my office. I have no idea what it was.
We've got a recess now, and I've got a judges meeting to go to. In spite of the importance of this proceeding, I still have some administrative duties. The reason we started half an hour earlier, I'm going to be in recess now till 2 o'clock. Court will be in recess till 2 o'clock.
Everybody remain seated till the judge is out of the courtroom. We'll be in recess until 2 o'clock.
Surely I wish I had some I think I'll just I was supposed to get gas yesterday, and we got no recess at all, and now I can't get gas again until tomorrow, because I know nothing will be open tomorrow. You mean on an odd day? They're not still enforcing that? I'll try. Yeah. The only trouble is Jim and I both have even numbers, so we could switch.
Oh, well, I can't give you mine, but mine is even.
Yeah, well, So we can't meet her if somebody has to find her.
I'm gonna take it upstairs because the guys wanna look at it, and if they want to, they have this time to look.
Okay.
Stick 'em up.
Which way you wanna go?
I could go.
Wanna go to the front? Come on. Okay, I'll see you Tuesday. Take care.
Talking a lot. If I left this here, would it be safe? Not gonna be good.
All this point.
That's all I have.
We'll take a little recess there. How much more time are we talking about, gentlemen? Let's try to do some organization as far as scheduling is concerned. I'd like to finish these matters tonight and be ready to start opening statements in the morning.
Judge, I've got a real problem with that. We don't even know what evidence is coming in.
You will know before the night's over.
Yes, sir. But I would really appreciate the court to give us the indulgence to let us work on the opening statement until Monday morning.
I think we've had that jury language and there all week, and I don't see any problem with getting opening statements behind us in the morning and then begin your evidence. You and I know that the defense probably wants to reserve their opening statement anyway, and if they want to, bless their heart.
Judge, I can tell you right now, we're not going to reserve the opening
All right,
statement.
then we're going to give it in the morning then.
Judge,
We're going to proceed with opening statements in the morning. I just want to find out how much later we're going to go tonight.
well, Judge, this motion itself, I don't know how long it's going to take. We've got to argue
We
it.
got 12, 13 more hours, and I just witnessed a man talking from 1 o'clock in the morning to 10 o'clock the next morning. That can't bother anything. So they're able to do that, I don't see why we're not able to.
Fine, Judge, that's all right.
You just want to go ahead and finish it tonight, and then we don't have to start it at 9 o'clock, at 9:30. We can start here at 10 o'clock in the morning. That's when I've got them scheduled to be here.
Judge, all I can say is that I would really enter an objection to it and request the court that the opening statement is going to be perhaps the most important part of the trial. And we've been working on these motions and have...
And I'm going to instruct them that the opening statement is not evidence, and they're not to consider it as evidence, and whatever the attorneys say is not evidence. And that's your most important part of this trial. We've been laboring on it for 6 months.
Judge, it's going to be the next most important part of the trial we're going to get to.
It better be the next most of it. You would just upset me a little bit if you said that was the most. I don't see any reason we can't proceed with open statements in the morning.
Well, I do, Your Honor, because my attorneys are not ready. They are entirely unprepared to start trial tomorrow morning. They have not even begun to put together the opening statement. They have not begun to decide who's going to be doing what in this trial. They are trying to catch up and not getting anywhere.
We started this trial a week ago, that we'll schedule opening statements tomorrow morning, 10 o'clock. We'll let the record show your objection, and we'll overrule it, and we're going to proceed at that time. We'll finish these motions tonight. We'll be in recess for 10 minutes.
We'll start it without me, Your Honor.
Everybody be seated.
We'll not be trial.
Mr. Bundy, sit down, please, sir. Court will now be in recess for 10 minutes.
I'm fine. Nobody. I don't care who he is. Nobody.
Watson? Prior stipulation, polling is waived and presence is noted. You may proceed, gentlemen.
Thank you, Your Honor. May it please the court, Mr. Bundy. Ladies and gentlemen, it's good to see you back again. In this case, Mr. Simpson spent a great deal of time telling you about the crime that was committed. And it is here at the outset, in defining the issues, that I can talk to you about the true question in this case. And the true question is not whether or not a crime was committed. Certainly there was a crime committed. No one disputes that the two young ladies were murdered in Tallahassee. No one disputes that the other two ladies were assaulted. No one disputes that the other lady was assaulted on Dunwoody Street. But there is a true issue in this case. Who committed these crimes? And that's what this jury has been impaneled to find. The issue is, did Ted Bundy commit this crime and no other man? The issue is, will the state prove that Ted Bundy and no other man committed this crime beyond and to the exclusion of every reasonable doubt?
Objection to the argument, Your Honor.
Don't argue your case, considerable latitude is given to state on conclusion based on no objection, and I will give you the same, but don't argue.
Thank you. I'm sure Mr. Simpson would agree that
Objection.
perhaps he does not agree. His Honor will instruct you that you are not to allow passion to come into this case.
I object.
That's argument.
We hope that the evidence in this case, because of the gruesome nature of the crime, will not cloud your reason. The issue, as I said, is what is the reliability of the identification? I'm going to take the state's, quote, best evidence here at the outset and tell you what I expect the evidence will show with respect to that. And their, quote, best evidence is Nita Neary, the supposed or alleged eyewitness to the intruder that was seen leaving the Chi Omega house on the early morning of January 15th. Expect that the evidence that the state will base most of their case on will be Ms. Neary's testimony. What I expect the evidence will show you in respect to that is that Ms. Neary came home at about 3 in the morning. She had been to what's called a keg party. She had been drinking beer that whole evening. She was tired. She was sleepy. She had a cold. And all of a sudden, she was surprised by seeing an intruder. At the time she saw the intruder, she paid no particular or attached no particular significance to it. She thought that it may have been one of the girls had smuggled one of her boyfriends in and he had stayed past curfew, or it could have been a burglar, or the first notion, she indicates, that she thought it was maybe Ronnie Ng, who was the houseboy in the Chi Omega house, and he had stayed past hours. And she wondered what was Ronnie Ng doing there at that late hour. When she saw the man leaving the door, she was standing in the subdued light of the evening, early morning hours, what has been called dim light. She was 16 and a half feet away from the man as he was leaving the door. She was standing behind him at a slight angle, an angle that only gave her a partial profile, what might be characterized as an oblique profile, just an angle shooting past his head, such as to give her the view that the intruder had a protruding nose or a prominent nose or a large nose. She saw this man for what has been called a fraction of a second, by her statement, 3 seconds at the most, and he was in a hurry. These fraction of a second, this glimpse, will become the most important seconds in this case. She will tell you that she saw the man carrying a log, what she thought to be a log, which later she thinks becomes a club. And she will admit that she saw the log for 2 seconds out of this 3 seconds. Most of her attention was what is called in expert testimony of Dr. Buckout, weapons focus. The evidence will show that when a person sees a man carrying a weapon, the person tends to focus more on the weapon than on the facial features of the man carrying the club.
Objection.
We have moved on that segment. You may say that you think it rather than reference to an individual.
Ms. Neary will admit that most of this glimpse, these few fractions of a second, were directed to this log. The evidence will also show that she only was able to discern the man was dressed in a dark hat, dark jacket, and light pants, which I expect the evidence will indicate to you that the reason she could not tell what color the man was wearing as far as clothing was because of the dim lighting. She will also admit that this intruder was constantly moving. His movement was flowing, it was fluid. And the first time she saw him was when he was at the door. The door opened easily. It was a freely hinged door that all these young co-eds were able to open without any difficulty. He turned the door, his back rotated, his body rotated, and he was through the door before her surprise even subsided. She will admit that there was no real facial perception, that she saw no expression on the man that would give her an emotional impression, to be able to have a more deeply emotional impression and observe and remember.
I object, Your Honor.
You're arguing the case now.
Expect that the evidence will show also that Ms. Neary had what might be called a subconscious expectancy to see.
I think you're commenting on evidence now, even though you say it will show it. That's a conclusion of which the jury must draw.
I expect the evidence will show that Ms. Neary thought she was seeing Ronnie Ng. Later, Ms. Neary identified another man, Ronnie Ng. She will tell you and admit that, quote, the similarities hit me between Mr. Ng and the intruder. She will admit that under hypnosis, she said, Mr. Ng, quote, it could be the same man that she had seen as the intruder. The expert testimony will show that later, Ms. Neary was placed under hypnosis, which is a state of heightened susceptibility to suggestion, where her attention is narrowed and concentrated, and it uses imagination, and it causes the suspension of what is called our critical judgment.
Objection, Your Honor.
I'll let him argue that.
And that during this heightened state of susceptibility to suggestion under the hypnotist, she was given inappropriate suggestions by the hypnotist towards her memory, that there was a systematic pattern of punishment and reinforcement of her responses.
I will sustain that. You're arguing the evidence now.
And I expect the evidence will show that under hypnosis, her responses were incomplete because the hypnotist did not allow her to make complete responses.
Objection.
I will allow him to make that.
I expect that the evidence will show, because of this hypnotic state, the hypnotist added to her memory unobserved details from the original event, that he altered what she did observe, and that he altered her visual memory of the original event. I expect that the evidence will show that also during this hypnotic session, she experienced what are called positive hallucinations, and that she saw things that were not there in the original event.
I object, Your Honor.
That's Mr. Taggart, I think you get close to the evidence.
I would ask the court to instruct the jury to disregard the comment.
The court already has.
You will have to examine, in determining the reliability issue in this case of Ms. Neary's observation, what her original opportunity to observe was and what her memory of that observation was.
Objection.
Sustained.
I expect that the evidence will show you that her memory had been contaminated,
Objection.
I'll let him say that.
that she had seen newspaper photographs of Mr. Bundy,
That's going into the evidence.
that during these newspaper photographs, she had seen at least 6 photographs of Mr. Bundy where she had become familiar with his face. And it is only because of this becoming familiar with his face in the newspaper.
Objection.
I'll sustain that.
All right. I expect the evidence will show that this newspaper familiarity caused her to make the identification
Objection.
I'll let him go into that.
later with Captain Pottinger. I expect the evidence will also show that she saw a sort of a profile of Mr. Bundy in the newspaper, aside from these other 6 photographs, that her mother, Ms. Neary, showed her these things. I expect that the evidence will show that she was not able to say anything more about Mr. Bundy when she saw him in the photograph than he resembles the man. I expect the evidence will show that she told Detective Bodiford that she couldn't promise him anything 3 times as to whether she would be able to identify Mr. Bundy. I expect that later the evidence will show the most hideous kind.
Objection.
I'll sustain that.
Expect the evidence will show that Captain Pottinger later suggested an identification of Mr. Bundy to Ms. Neary.
Objection.
Well, if that is summation of what the evidence will show, I'll allow him to make it.
I expect that the evidence will show that he told Ms. Neary that she was to look at the prime suspect. And even after he told her this, suggesting for her to make the identification of Mr. Bundy,
Sustain.
Objection.
that all Ms.
Your Honor,
Neary...
why does Mr. Haggard
Well,
continue after the
I
objection?
assume he's
Knew
starting on another sentence.
Yes,
Mr.
Your Honor, I am.
Simpson. If he gets back on that one, I'll take care of it.
Okay, thank you.
And after this conversation between Ms. Neary and Captain Pottinger, the best Ms. Neary could say was, "He looks like, it fits closest." And I expect that you will see from the photograph that Captain Pottinger showed to Ms. Neary a subtle form of suggestion.
Objection.
I'll let him conclude that. Don't go into what it is.
All right. And I expect that you will see in the photograph that Mr. Bundy was the only man wearing dark clothing. And I expect the evidence will show that after Ms. Neary saw this photograph, she said about it, quote, "I don't know," referring to whether it was the man. Quote, "I
Objection to
don't
what
know."
he thinks she was referring to.
Don't, I sustain that. Now, don't go into that. That's argument, Mr. Haggard, within the confines, as you know.
And then later, Ms. Neary was taken to the courtroom in Tallahassee, where this case was first set for trial in October, and shown again Mr. Bundy, where he was the only man present in the courtroom, and she was asked to identify him there.
Objection.
Overruled.
And the best she could say then, after having seen him in the newspaper, having seen him in Mr. Pottinger's photograph,
Go back over the evidence you're arguing now.
all right, the best she could say when she was in the Tallahassee courtroom was that it, quote, "looked like the man." And I expect that the evidence will show, and she will have to admit, that she saw a, quote, good right profile of Mr. Bundy in that courtroom, and that she had an ample opportunity to observe him. And there was no positive identification there.
Objection.
And I expect that the evidence will show that last week Ms. Neary said about Mr. Bundy, again, only Mr. Bundy being present here in this courtroom.
Now, Mr. Haggard, I want to caution you before you say that all that was out of the presence of the jury, and if you open the door, I'm going to give the state some time to go into it. Go ahead, sir.
Ms. Neary has never been certain in her identification. And what you will find is that only her confidence grew after repeated and repeated suggestions.
Objection.
Sustained. That's argument now, Mr. Haggard. Bless your heart.
I'm sorry.
Come aboard now.
I expect that the evidence will show that she was asked time and time again to make an identification by the police. And I expect that the evidence will show that her confidence is not a measure of her accuracy of her original observation.
I'll let him say that. That's what he intends to show by the evidence.
Now, that is Ms. Neary's testimony.
Now, that's argument in and of itself, Mr. Haggard, isn't it?
Let me treat this so-called bite mark evidence. And I expect that the bottom line on this evidence is what we are going to show to you, and I remind you that we have no burden of proof, but notwithstanding that, we're going to show you that there are 4 or more other sets of teeth that match the same bruise marks. That there are more teeth that could make the same bite marks. There are many problems. There are many reasons. I expect that the evidence will reveal to you as to why Dr. Souvron's opinion has no reliability. First of all, it's common sense that
Now, that's argument.
I'm sorry, Your Honor.
You and I know that. Go ahead.
I expect the evidence will show that the skin is not the best medium for retaining an impression. It's not like you're biting into an apple or something.
I'll let him say that.
I expect that the state will not be able to show the dynamics of this alleged bite. I expect that they will not be able to show you what position the body was in at the time this bite was made, whether the leg was flexed, extended, how the skin was stretched, and this evidence will show that the elasticity of the skin is an extremely important issue in determining the dynamics of the bite. I expect that the evidence will show that there were 2 possible lower rings, meaning the lower jaw, that there were 3 possible upper rings, and that the 2 lower rings cannot be correlated with the 3 upper rings. So there's no way to ascertain the leverage of the bite. I expect that the evidence will show that this was a bruise, and as a source of a bruise, the body bleeds and it diffuses, which gives nothing but gross characteristics, subjectively gross characteristics. Expect that the evidence will show that this opinion testimony stretches the farthest fantasies.
Objection.
Sustain that now. That's
Sorry,
argument.
Expect that the evidence will show that there is no generally accepted standards for bite mark comparison, that there's no agreement as to what is consistent or inconsistent, or what constitutes reasonable dental certainty or reasonable dental probability. Expect that the evidence will show that there's no convention in the dental profession as what constitutes a valid, sufficient number and substantial number of points of comparison and types, and how many are necessary to make a reliable identification. Or what is the proper method to be used. I expect the evidence will show that there is an element of what may be called the Heisenberg principle of uncertainty that is operative in this case.
Isn't that argument, Mr. Hager? I can't get any results this way. I'm going to ask you now.
Well, Your Honor, to me that's a definite concept. And
All right. I'll be guided by what you say sometimes.
thank you. It will come down to the bottom line, as I said to you at the beginning of my remarks on these teeth, that we are going to show you that there are 4 or more other sets of teeth that match the same bruise marks. And that's as far as we have to go, or need to go.
Now
And
that is
answers the
argument,
question.
Mr. Hager.
I'm sorry, Your Honor.
As well as I do.
I expect that the evidence will show that this alleged hair cannot be characterized better than the 3 races unless there's some individual. I expect that the evidence will show that this alleged hair cannot be characterized better than the 3 races unless there's some individual characteristics, something peculiar like dyed hair, that there's must be certain morphological characteristics, and there will be doubt as to its reliability all the way down the line.
Objection.
Sustain, disregard.
What I expect that all the evidence will show in this case is that this evidence, quite candidly, is manufactured.
Objection.
Now, Mr. Hager,
I'm sorry, Your Honor.
there's going to be a line of no return. If you want me to do it, go ahead. That's not proper for an open statement. You know that as well as I do.
I expect that after you examine the soundness of the reasons in this case, you will certainly have reasons for reasonable doubt.
Now, let's go into that.
And these reasons for reasonable doubt, I expect, will continue with Ted Bundy throughout this trial and right till you retire into the jury room. It is based upon those reasonable doubts that I believe that you will find Ted Bundy innocent of these charges.
Objection.
Mr. Hager.
Yes, Sean.
That's the end of the line.
Thank you, ladies and gentlemen.
Ladies and gentlemen of the jury, we are going to recess at this time. We're going to discharge you first and let you return back Monday morning at 9 o'clock. We'll again caution you while you're in sequestration, do not discuss this case or what you've heard among yourselves or with anyone else, nor permit anyone to discuss it with you. Mr. Watson, you may take the jury out, and everybody in the courtroom will remain seated.
Will the jury please follow me?
Gentlemen, ladies, we will start again Monday morning at 9 o'clock and follow as close as we can the schedule that we outlined this morning for the time that testimony is being taken in front of the jury. There'll be to recess close to the noon hour, assuming again about 1:30, and go until about 6 each day as best we can during the course of the trial. Any further considerations by either side at this time? Anything further that you need? Ms. Good?
I'd just like to point out that Ms. Edge did state that she was diabetic and had to have regular meals, and I thought maybe you want to ask the jury if that schedule is sufficient as far as meal planning goes.
We have checked on about what time they're being fed now, and it's consistent with, that's one of the reasons we are going to follow that fairly close. By the time they get back over there, it's indicated it's close, similar to the schedule that they're running, and we'll give them the new meal and give them time to be here on time. I was concerned with the same thing. I appreciate your interest in it. All right, we'll be in recess then until Monday morning.
Great dispatch, everyone. Out of the courtroom.
But the problem is that my four attorneys simply haven't been working on the case long.
Ted Bundy made one final plea for more time. It was denied, just like the dozens of other motions he has made during the last 2 weeks of pretrial proceedings. The judge, obviously growing impatient, on Saturday ordered the trial to begin. Bundy is on trial for the strangulation murders of 2 Florida State University co-eds. In opening arguments, the jury heard for the first time the grisly details of the crime and how much of the argument in the trial will center on bite marks left on one of the victims.
The defendant in this case, Theodore Robert Bundy, was responsible for leaving those bite marks on the buttocks of Lisa Lee.
We're going to show you that there are 4 or more other sets of teeth that match the same bruise marks.
The trial is expected to last 6 to 8 weeks and will be the first of a series of trials for Ted Bundy. Bundy is suspected in 19 other murders as well. Rebecca Chase, ABC News, Miami.
Had you had any training or medical instruction yourself?
Yes, sir. I was certified in CPR and advanced first aid.
You indicated that you found her, Ms. Bowman, covered up to her neck, is that correct?
Yes, sir, it is.
And you also indicated that you pulled the cover down.
Correct.
You then indicated that you grabbed her by the shoulder and rolled her partially over, is that correct?
Yes, sir, about halfway over. She was lying on her stomach, her head was tilted this way. I just grabbed her by the shoulder, pulled her over, confirmed that there wasn't any type of pulse, and then just let her roll back into her natural position that I found her in.
Did you notice any, or can you at this time tell us anything about her body coloration or temperature that
She was warm. She was warm to the touch. There were certain bruises upon her face starting to form, which I learned later from the pathologist.
I just like your own knowledge, if you would please.
Yes, she was warm to the touch. She did not feel to me that she had been deceased that long. Of course, she did have a blanket on her, and that has a direct bearing on her body temperature. Rigor mortis had not set in.
What's the condition of her eyes?
Her eyes, her eyes were open and filmy.
Did you process anything in that room yourself?
No, sir, I didn't. Her pupils were dilated.
Pupils were dilated, is that?
Constricted. Constricted. Excuse me.
Meaning what?
No, wait a minute.
Do you have that note in the report?
No, I don't. Her pupils were enlarged, dilated. I was right there.
You mentioned a mark on her breast. Would you describe that, please?
Yes, sir. It appeared to be a bite mark. Yeah, I said
victim at this point, right?
He's talking about.
This would be least legal.
on this league, as I said, I wasn't in the room a great deal, extremely long period of time. The EMTs were performing CPR on her. I came over, I looked at her. She appeared to be deceased to me, and I noticed a bite, what appeared to me to be a bite mark, teeth marks in her right breast.
Was it a laceration?
It appeared to be bite marks, like I took a bite of an apple, and the teeth and dentures remained in the skin. The entire piece of skin was not totally bitten out. It's kind of like when you take a bite of an apple and don't bite anything out, but your teeth and prints remain.
How close were you to her?
3 feet away. I was leaning over looking directly at her.
The other people were there also?
Yes, sir.
Did you examine her yourself?
I observed her. I didn't physically examine her.
Okay, what was transpiring at the time of that observation?
The EMTs were performing CPR on her, and I believe inserting an IV into her arm.
What is entailed in the CPR? What is that?
CPR consists of blowing breath into her mouth and giving her heart massage, wherein the person performing the heart massage gets on her side. The EMT was on her left side. He was directly over her with his hands placed approximately right here, both hands. He was at a 90-degree angle, pumping down on her chest.
And this was occurring at the time that you observed her?
Yes, sir. His hands were placed approximately 2 fingers above the sternum, which was where your rib cage kind of V's up here at the top.
How long were you in that room?
After I arrived on the scene?
In Miss Lee's room. How long were you in that room?
In Miss Levy's room? I was in the room probably 1.5 minutes, 2 minutes. I walked in the room probably 1 minute to 1.5 minutes after I parked my car outside.
Should you do any investigation after this?
I did some footwork as far as walking around the neighborhood. I was assigned a certain area around the Kaimeg house, and I went door to door a day, 2, 3 days after this occurred, asking residents of the various apartments and houses if they saw or heard anything that night that could possibly help us.
Did you discover or stop any persons on the streets?
Put some material out there, counsel.
I withdraw the question. You indicated that you made a brief check exterior of the Chi Omega house, is that correct?
Yes, sir, it is.
Did you locate any physical evidence at that time?
No, sir, I didn't.
Did you later locate any physical evidence?
Objection. I'll let him answer that.
No, sir, I didn't.
One moment, Charles.
Yes, sir.
You testified that you witnessed both autopsies, is that correct?
Yes, sir, it is.
Which one occurred first?
I'm not exactly positive. It's not my report. I believe that it was Miss Bowman that was first, but I'm not exactly sure.
Were you in the Chi Omega house at the time that Miss Levy was taken from the room?
I was in the Chi Omega house at the time she was taken from the room. I was not in the room when she was taken from her room.
You know who took her from the room?
Emergency medical technicians. They performed life-saving technique on her as they were leaving the Chi Omega house.
So she was being assisted and aided the time that you were there, the whole time that you were there?
Correct.
How long was that?
They probably had her transported and on her way to the hospital 10 to 15 minutes after I arrived.
And what time did you arrive?
Approximately 3:35.
Did you accompany either of the women to the hospital?
Miss Bowman.
Did you see Miss Levy any time at the hospital other than the autopsy?
I saw her in the morgue. And the morgue and the autopsy are synonymous.
Did you see her being moved either out of the emergency vehicle or around in the hospital?
No, I didn't. When I got to the morgue, Miss Levy was in the morgue.
What time did you get there?
Approximately 4:15 to 4:30.
Officer Winter, did you notice any processing of the fingerprints, body prints at the hospital?
Yes, sir. Yes, sir. There were finger scrapings at the hospital that I observed. By finger scrapings, what I mean is the ID technician took a sterile pick and with a vial underneath that was also clean and free of any debris, he scraped the girl's fingernails to get out any material that might be lodged underneath them, such as if the victims had scraped their assailant, possibly some skin, blood, something like that would possibly be under there. I'm not.
Who did that?
Officer Johnson.
Did you notice any attempt to remove fingerprints from the body?
I did not observe them remove the fingerprints.
No further questions.
You redirect?
Nothing further, Your Honor.
May this officer be excused.
Yes, sir.
Mr. Thompson, may this officer be excused.
Yes, Your Honor.
Thank you. You're free to go, sir.
excused from Miami?
Yes, sir. Elected person. Go ahead.
Call Officer Ray Crew, please.
Ready? Come right over here, please, sir. Step up to the witness box and raise your right hand.
Do you solemnly swear that the testimony you will give the truth, nothing but the truth, so help you God?
Please be seated, sir.
Would you state your name for the record?
My name is Raymond Crew,
Spell your last name for us.
C-R-E-W.
What is your occupation or profession, sir?
I'm a police officer at Florida State University.
How long have you been so employed?
4 years.
And what are your duties and responsibilities with the FSU Police Department?
Routine uniform patrol, basically.
Okay. Officer Crew, were you on duty on the early morning hours of January 15, 1978?
I was.
And were you performing in the same capacity or had the same duties then that you do now?
Yes, sir.
Okay. Officer Crew, on that morning of January 15, 1978, were you dispatched to the Kyle Mega House in Tallahassee?
Yes, sir, I was.
And what time were you dispatched there?
The white card that the dispatcher punched stated 3:26 a.m.
Okay, and what time did you arrive?
3:26 a.m.
Okay, approximately where were you at the time you received the call?
Approximately a block and a half west of the house.
Okay, and did you proceed immediately there?
Yes, sir, I did.
What did you find when you got there?
As we arrived, a young lady was opening the door. Oscar Brandon with Tallahassee Police Department was also arriving at the same time. He went in the door, and I went in the door, and was directed upstairs.
Okay, you went upstairs?
Yes, sir, I did.
How was it that you came to go upstairs?
Someone, one of the girls that was in the lobby, stated upstairs, and so I proceeded upstairs.
Was that her exact words?
Yes, sir.
Okay, and did you go upstairs?
Yes, sir, I did.
How did you go about getting up there?
I used the stairway. It was on the north central part of the building, inside.
Okay, in the foyer area?
Yes, sir.
Okay. What did you find when you got upstairs, sir?
There were several girls in the north hallway, and they directed me down the hallway to a room that was on the corner on the southwest end of the building. And I proceeded down to that room and observed Kathy Klein.
You observed Kathy Klein?
Yes, sir, initially.
She was the first one that you saw when you got there?
Yes, sir.
Okay. And what room was she in connected?
Based on my report, shows it was in room 8.
Okay. And what kind of condition was she in at the time that you saw her?
She was bleeding profusely from the face and head. She appeared to have a broken jaw, and there was a considerable amount of blood on her bed and on the sheets around her.
Okay. Where was she exactly in the room when you saw her?
As you entered the room, she had been on the bed on the left-hand side.
Okay. Now, was anyone else there with you at that time?
Officer Taylor was still downstairs. He and I had been riding together. We'd arrived at the same time. So I was initially the first one upstairs, as I mentioned.
Okay. Were there any EMTs or other medical personnel upstairs?
Not at this time.
Okay. So what did you do for Miss Klein at that point?
There was not a whole lot I could do. Someone had brought her a small plastic bucket or pail and placed it under her chin to catch the blood to keep it from basically running all over the place. She was a little incoherent. I just asked one of the other girls to stay with her to keep her mobility down, keep her from moving around much. She didn't know if she had any other injuries or anything internal. So then I went back out into the hallway.
Okay. And what happened next?
I was directed down to another room, which was on the north side of the hallway, about the center way down, and was advised that there was another victim there.
Okay, and who?
Simpson, Mr. Watson, give Dr. Boyd.
How you doing? Okay.
So you went down the hallway,
Yes, sir.
and to what room did you go?
According to my report, it was room 3.
Okay, and what did you find in room 3?
Karen Chandler was prostrate on the floor. She was bleeding also, and there were one, possibly 2 other girls that were in the room with her.
Okay, what do you mean by prostrate on the floor?
I mean, she was laying on the floor face down.
Come on, Madam Report.
Testimony of the gruesome, gory nature will become so highly humorous as to be prejudicial. What was the sensitive was parading one officer right after the murder. My observations is this may be making Mrs. Edge sick. And who was one of our jurors, Mrs. Edge?
Do you think that's making her cough?
Could be.
Sounds to me like there's something dripping in her throat. I don't think that's got anything to do with it. It might be, but I doubt it. I've been coughing with it myself and then
Well, yeah, in any event,
that's a figment of the defense imagination.
I can't substantiate that point one way or the other.
I understand that. I just wanted to recognize
Now, let me ask you a question. Seems to me there's an element in the story that commit murder, which is one extension of the element and the severity of that is the basis upon which they're charged with murder. There's no question that that's an element of purpose for what kind of charge. However, the evidence becomes clear about saying one officer got after another to describe the same scene and circumstance, cumulative detail, and large.
This is the last witness I'll be testifying on findings. And then we'll move to the EMT.
What's the medical testimony? Including pictures, of course, from what inconsistent with the law.
Officer Crew, you were telling us about Ms. Kleiner?
No, sir, Ms. Chandler.
Ms. Chandler, I'm sorry. Okay, were you finished with what you were telling us about what you observed when you saw her? You indicated she was lying flat on the floor.
Yes, sir, lying face down on the floor and was bleeding from the head.
Okay. What happened after that, sir?
Officer Taylor arrived upstairs about this time with some EMTs, emergency medical technicians, and they began treating Ms. Chandler, and they were directed down the hall to Ms. Kleiner's room also.
Okay. What happened after that?
I began a room-by-room search to see if there were any other victims or potential witnesses, and I started at the northwest corner of the north hallway.
Was anybody with you while you were doing that?
The house mother was sort of trailing behind me. She was up and down the hall, fairly active, but as far as anyone actually accompanying me, no, sir.
Okay. Okay, so what happened next?
I entered, I can refer to my report. I entered another room that was, I believe, was room 7. No, excuse me, that was a different room. I don't have a note on Miss Levy's room. I went into another room, room 4, it is, and observed a young lady lying on the right-hand side, basically face down with the sheet pulled up. I thought she was asleep, so I approached her and attempted to awaken her.
Okay, let me ask you this. Whenever you got to room 4, would you actually describe for us how you entered the room?
The door opened to the left. I just turned the knob, pushed the door open.
Was it closed at that time?
Yes, sir, it was closed.
Okay. So what happened then? Whenever you entered the room?
The light was off. I had to turn the light on. And as I said before, I observed the young lady lying in the bed on her right side, basically face down, with a sheet pulled up. And the house mother had approached and was standing at the door, and she told me the girl's name. And I called out to her, and it didn't arouse her.
And what did you say to her?
The house mother said her name is Lisa, so I called. I said, Lisa, wake up.
Did she wake up?
No, sir.
What happened then?
I reached over and approached the bed and reached out and shook her.
Okay. What response did you get?
None.
What happened then?
At this point, I started to roll her over on her back. I observed a small blood stain on the sheet, and I stopped at that point and told the house mother to get an EMT.
Okay. What happened after that?
At that point, I rolled her over on her back and attempted to find the pulse and could not. And shortly thereafter, the EMT entered.
Okay. Describe that for us, if you would, please.
Describe what, sir?
What happened next?
The EMT came in and attempted also to find a heartbeat and was unsuccessful. Officer Taylor entered the room about this time. The EMT eventually said that he'd gotten a heart fibrillation, and Miss Levy was taken off the bed, placed on the floor, and CPR was started on her.
Okay. Could you describe Miss Levy as you saw her that morning?
Her complexion was pallid. Her lips were bluish in color. Her body temperature was way down. She was almost cool to the touch. When her eyelid was raised, her eyes appeared a little glassy.
Okay. Could you describe for us any injuries that you observed to her body at that time?
Initially, I observed a puncture wound through the nipple in the right breast. When the sheet was pulled off of her and she was moved to the floor, I observed a bloody mark on her right buttocks.
On what?
On her right hip.
And how was she dressed?
She had on a nightgown, but it was open in the front. It was just a regular nightgown.
Did she have on any underwear, any undergarments?
No, sir.
As you first saw her in bed, where were the covers that went to her bed?
They were pulled up about approximately halfway over her head up to her ear.
Did you have to remove the covers yourself?
I pulled them back, yes, sir.
What about when she was placed on the floor?
I don't recall who, but the covers were just flung to the foot of the bed and she was taken off and put on the floor.
Okay. What happened after that? You indicated the EMTs began CPR on her.
Yes, sir, the EMTs and Officer Taylor began CPR on her, and I stepped out of the room in order to give them room to work. And the house mother made a statement to me that Margaret was home but had not yet come out, and asked me to please check her room also.
Did you check Margaret's room too?
Yes, sir, I did.
Which room was that?
According to my report, that would have been room 7.
Could have been room 9?
Yes,
Your Honor, I think you have to.
Don't leave your witness.
Yes, sir. Okay. So what did you do next, sir?
I proceeded to the room that the house mother had directed me to. I opened the door. Once again, the light was out, and I had to turn the light on.
What did you find?
As soon as I turned the light on, I observed that there was a young lady. She was in a bed. The bed was on the right-hand side against the wall. There was a lot of blood on the walls. The covers were pulled up to almost covering the head once again. But there was a large amount of blood around the top of the head and splattered on the walls. I knew I had another victim, so I closed the door.
Okay. Did you actually go up to her and examine her?
Yes, sir, I did. I walked up and pulled the covers back and observed that she appeared to be dead.
Okay. Did you see any debris in the room?
Other than blood splatters on the wall, none at that time, no, sir.
No further questions, Your Honor.
Mr. Thompson? Mr. Bundy? All right, please go on.
Good morning, officer.
Good morning, sir.
You've testified here this morning that you recall arriving at the Mega House approximately 3:26 a.m.
Yes, sir.
And were there officers there in addition to Officer Brandon when you arrived?
No, sir. As I arrived, I parked in the driveway and I observed Officer Brandon jumping the curb and parking on the front lawn. It was almost simultaneous.
And you were approaching the house as he was entering the house?
We went up the walk, yes, sir, together. He was just exiting his car as I did.
You recall the lighting in the area?
There was a porch light on, and there are some street lights on Jefferson Street.
And who met you at the door?
I don't know the name of the young lady, sir. There was 2, possibly 3 young ladies in the foyer, but I did not get any of the names.
Were you present when either one of the persons who met you at the door gave a description to Officer Brandon?
No, sir, I was not.
You went immediately upstairs?
Yes, sir, immediately upstairs.
The first victim you saw was Kathy Kleiner?
Yes, sir.
Did you speak to her?
No, sir, not directly. She was in shock, or appeared to be in shock, and was incoherent. So talking to her would have been to no avail.
And then you next encountered Karen Chandler?
Yes, sir.
Did you speak to her?
Yes, sir.
Can you recall that conversation?
Not word for word. The gist was that she did not know what had happened. She knew she was hurt, and she was concerned about Kathy.
You recall her telling you that she remembers the assailant being young?
Objection. Restate the question.
Do you recall her saying anything about whether she remembered being assaulted?
No, sir. I basically just inquired as to her condition and the seriousness of her injuries, how she felt.
Next, you approached room 4, is that correct?
The room, according to my report, I remember to be room 4, yes, sir.
Now, your testimony, the door was closed?
Yes, sir.
How did you enter the room?
I turned the door handle and pushed the door open.
With the same hand, or did you use one hand to put on the door handle, the other hand to push on the door? How did you enter?
I turned the door.
I'll let him answer.
Turned the door handle with my left hand and pushed it open with my left hand.
Then, to the best of your recollection, almost step by step, if you can, officer, what did you do next?
Step by step, used my right hand to turn on the light, turned partially to my left, observed the young lady lying in the bed. I took 1 or 2 steps toward her, and that's when I heard the house mother behind me. She told me the girl's name, Lisa, and I spoke to her.
All right, now, were you wearing gloves?
No, sir.
Your hands were bare?
Yes, sir.
You called out Lisa Levy's name?
I called Lisa. Yes, sir.
Then what did you do?
Then I approached the bed and shook her in an attempt to awaken her.
Can you describe what you saw, the bed and Miss Levy at that time?
As I stated, she was lying on her right side, her face turned toward the wall, and I grasped her by the left shoulder when I shook her.
Was she covered or uncovered?
She was covered all, completely up to about her ear. Most of her body was covered.
And then what did you do?
When I was unable to awaken her by shaking her, I started to pull over on her back.
You attempted to?
Well, I started the motion of pulling her over on her back.
And then what happened?
I observed a blood spot on the sheet, and I stopped at that point and told the house mother to go get me an ambulance technician.
And did you wait until the EMT, the ambulance technician, arrived?
No, sir. As soon as the house mother stepped away, I rolled her the rest of the way on her back.
And was she still covered?
I had pulled the covers back some by then, so she was covered from the waist down.
Did you do anything else in that room before the EMT arrived?
I attempted to find a pulse on Miss Levy.
Anything else?
No, sir.
Did you touch anything else in the room prior to the arrival of the EMT besides Miss Levy?
Other than the light switch, no, sir.
Remember the name of the ambulance technician who entered the room?
No, sir, I do not.
Is it male or female?
Male.
What was the first thing you did when that technician entered the room?
I advised him that I felt that Miss Levy was injured and needed his care, and that I had been unable to find a pulse beat, and that she was turning cold.
At whose suggestion did you place Miss Levy on the floor?
It was the EMT's idea. Once he said that he felt that he had a heart fibrillation, he wanted to administer CPR, and he needed more support on her back to administer the CPR than the bed would afford.
Best as you recall, how was the act of removing Miss Levy from the bed to the floor accomplished?
Officer Taylor, I believe, took her feet and knees, and the EMT supported her shoulders, and she was lifted and placed on the floor.
On her back or on her front?
On her back.
Then what happened?
Then they started the CPR on her. Officer Taylor had an airbag that he was squeezing for the breathing, and the EMT started the heart massage.
You were just witnessing this procedure?
Yes, sir. I had stepped back in order to give them room, and then I left. Once they started the CPR, I left.
Did you subsequently come back to the room?
Yes, sir. I came back, but it was a while later after I'd been to Margaret's room.
And what did you observe in Miss Levy's room when you returned?
I observed two EMTs the second time I went back, and Officer Taylor, and they were still administering CPR.
And was she still in the same position as she was when she was first removed from her bed?
As near as I can recall, yes, sir.
Could you describe the condition of room number 4, of Lisa Levy's room when you entered it?
It's a bedroom. I recall various pieces of clothing strewn about. Yeah, a desk with some books on it. Just a standard type dormitory room or a sorority room.
Did the room look neat, or did it look as if it was in disarray at the time you first entered?
There was some disarray. As I stated, there were miscellaneous pieces of clothing draped about.
Did you notice blood on any areas of the room other than what you've testified to earlier?
No, sir.
Officer, when you entered Margaret Bowman's room, let me take you through the same step-by-step procedure we did before. Was the door closed?
Yes, sir, it was.
And did you open it the same manner you opened the door in room number 4?
No, sir, I used my right hand. The door opened to the right, and I used my right hand.
And what did you do next?
Once again, I turned on the light switch and turned to my right. She was occupying the bed against the right-hand wall. And observed.
Can you describe the condition of that room with respect to whether there were things laying around or whether it was neat, or just how it looked to you?
My concentration was basically on her. I remember some clothing on the other bed. And there was a table there also that had some clothing on it.
Now, you've testified that your recollection, well, let me ask you this. Did you notice the trash basket, the waste basket in the room, or if there was one in the room?
I didn't notice, no, sir, if there was one or not. I didn't notice.
Now, what did you do when you first, after you first turned on the light?
As soon as I observed her and the blood, the amount of blood in the area around her head, I immediately closed the door.
You were inside, you closed the door?
Yes, I stepped inside and closed the door.
And then did you approach the bed?
Yes, sir, I did.
And did you touch Miss Bowman?
No, sir, I didn't touch her body. I lifted the covers back so that I could observe.
She was covered?
Yes, sir, the covers were pulled up, covering half of her head to the ears.
And can you describe what you saw when you lifted up the covers? As much detail as you can recall. If you need to use your report, please feel free to do so.
She was lying basically face down, whether a little more than half of her face exposed. She was turned toward the wall. There was a considerable amount of blood around her head, matted in her hair, on the walls. Her mouth was open, her eyes were open. There was what appeared to be a nylon stocking netted around her neck. Her head was apparently bloated, discolored. I did not touch her body, so I can't say what the body temperature was.
Officer Crew, you were referring to a document in front of you, were you not? To refresh your memory?
I was just glancing at it. No, sir, I was basically calling on my memory.
Did you see any other pantyhose in that room at that time?
I don't specifically recall observing him as such, no, sir.
And you cannot recall any debris other than blood? Is that your testimony? Is that your recollection?
That's the best of my recollection, yes, sir.
Going back to the time you entered Lisa Levy's room for a moment, directing your attention to that occasion, can you describe the exact position, as best as you can recall, of Miss Levy's body as you saw it when you first entered the room?
It's actually repetition. He's previously described it.
Recall the position of her arms.
Her right arm was underneath her. I seem to recall that her left arm was down her side and across her stomach. Miss Levy,
Miss Levy, we're talking about, yes, sir. Now, can you recall the position of her legs?
I seem to remember that her right leg was basically straight down her body, and her left leg was in front of it, sort of flopped over.
Now, were you seeing this directly or indirectly? What I mean is, did you
A little of both. Basically, indirectly, I saw her, I could see the outline of her legs through the covers.
Did you notice any debris in Lisa Levy's room?
No, sir.
Officer, when you first entered the Chi Omega house on the morning of January the 15th, can you tell me what lights were on in the foyer area, that area just inside the front door?
I remember that the foyer lights were on. Which ones, I do not recall. I know from experience that there was a lamp immediately in front of the doors, but I can't recall if it was on or not.
You say from experience?
Yes, sir. I've been to the house many times.
Had you been to the house before January 15th?
Oh, yes, sir.
Have you been to it since?
Yes, sir.
In relation to this case?
No, sir.
After you left Lisa Levy's room for the first time, you then went down the hall where?
To Miss Bowman's room.
All right, and then after you left Miss Bowman's room, where did you go?
I went down to Miss Kleiner's room to get the shift commander who had arrived at the scene by this time.
Who was that?
Sergeant Paramore.
Did you have an occasion to later go downstairs after you had investigated the situation on the second floor?
Yes, sir, but that was much later.
How much later?
30 to 45 minutes later.
And at sometime on the morning of January the 15th, you transmitted a radio description of the suspect or the individual seen leaving the house, did you not?
Yes, sir, I did.
When did that occur?
I believe it was after I had already been to Miss Bowman's room.
Were you upstairs or downstairs?
Upstairs.
Okay. How did you manage to get this description out over the police radio?
Objection to Terri Caldwell. I'll let him answer the question.
I don't understand the question, sir.
How was the description you gave broadcast over
Yes, sir.
police frequencies?
Yes, sir, I broadcast it, and then the dispatcher repeated it.
Can you tell me what a bolo is?
That's an anagram standing for be on the lookout.
Is that essentially what the description you gave that morning was, a bolo?
Yes, sir.
Do you know if that description was transmitted, broadcast to other agencies other than the Florida State University Police?
Objection to the Terri Caldwell. I'll let him answer if he knows.
If you know.
I advised the dispatcher to call the other agencies.
Do you know whether the description you broadcast, the bolo, was given before or after Officer Brannon's description of the individual seen leaving the house?
It was after.
Did you speak to Officer Brannon that morning about the description of the subject seen leaving the house?
Yes, sir, I did.
And did he give you a description of that individual?
Yes, sir, he did.
And was it that description that you broadcast?
No, sir, it was not.
Had you talked to anyone else in addition to Officer Brannon, who gave you a description of the subject seen leaving the house?
Yes, sir, I did.
Who did you talk to?
Officer Taylor and also the police dispatcher on the radio.
Didn't you also talk to Officer Kelly?
That was later on, yes, sir.
That was after your broadcast of the description?
Yes, sir.
Did you ever speak to Nita Neary that morning?
No, sir.
Did you interview anyone else other than Karen Chandler that morning? Did you interview any of the other residents of the Chi Omega house that morning?
I spoke to some of the other girls, but I did not take down any names, and I did not use any of the descriptions in my reports.
Did you process any of the areas in the house for fingerprints?
No, sir.
Did you witness any photographs being taken at any of the points in the crime scene?
No, sir.
And when did you leave the Chi Omega house that day? You can recall.
After the investigators from my department in the sheriff's office and the city police had arrived, there was a briefing session in the dining room area where I was called in, and I told them what I had seen and what I had done. At that point, I was advised that I was to return to patrol and to assist in the search of the area.
And did you have an occasion to stop persons
Objection.
who fit the description of the person
Let him
seen leaving the house?
Complete the question.
Excuse me?
Complete the question, and I'll rule on it.
My question is, officer, after January the 15th or any time after you left the crime scene, did you have an occasion to stop an individual or any individuals who fit the description of the subject seen leaving the Chi Omega house?
Objection. I'll let him answer.
It was a fairly broad description, so I stopped several individuals, yes, sir.
It's a fairly broad description, sir?
Yes.
Did you have an occasion to, well, let me ask you this about those stops. Can you tell me how these persons fit the description?
Objection. I'll sustain that.
Do you recall the names of the individuals you stopped?
Objection. Sustain.
Did you make reports based upon your stopping of these individuals?
Objection. Terry, I'll let him answer that.
We fill out a card that's called a field interrogation report, basically listing name, address, what they were wearing, where they were going. And I filled out some of those, but I do not recall other than that.
You don't recall anything specific about any of those stops that you made?
No, sir, other than the subject fit the general description.
Where's a bigger box?
Let me tell you something.
Sure, that's the heaviest box in.
It must be the Jared Thompson file.
Yeah, that's the inconsistent statements file in Jared Thompson.
You know what's been on my mind since I've been in here? You know.
You've got to be
I'm
kidding.
telling you, that's all I'm thinking about.
You miss me?
Oh, yeah, I do. You know, every day. Yeah, he doesn't like me to be late.
No? You're watching her.
Oh, yeah. Watching it, watching it, are you?
He's a testify.
Yeah. If we had him for what, they would get more of that paper.
He's nice.
Yes, he said, should be seated. I said, he's seated.
Yeah, you don't take no belongings. He's the boss.
Since I took that, the closest I can get.
He's got my leg, my left one, I'm always gonna get it. Cut it out. Cut it out.
You're on camera.
On camera, everything. I can't believe it. Now tonight my wife was sitting there watching that and all of a sudden she going up, listen to the conversation. It was fixing to it. You don't take much of that rubber there. I thought I was too old the other day, and again right now, I still got life, I'll tell you that much. And here I thought I was fading out.
This thing is sticking up, you gotta fly.
Well, I missed shoes.
You seen Gloria?
He's been around today.
Everybody rise, please. Please be seated. Court will come to order. You have Mr. Allo to call? Or?
Your Honor, I think that we can just do it by way of stipulation. The only thing we wanted was the measurement from the spot where Anita Neary said she was in the foyer to the front door.
Well, isn't it on our diagram?
It doesn't have a measurement on it.
Yeah, but it's got a scale, isn't it? See something about
Got a scale, I see it
2
from
inches
here.
equal 1 foot or
No, that's
something?
the wrong one. Yes, sir, I think that we agreed that the measurement is 19 and a half feet.
Isn't that scale on there 2 inches equal, half inch equal 1 foot?
Equal 1 foot.
Well, I'll take it from there.
Somebody over there.
No, I took that one back to the idea. We have to do it right now, I'll go get a ruler.
The diagram is in evidence. The 2 spots have been marked as best we can ascertain.
All right.
And you can put a footage ruler on there and then read it from it.
All right, and the only other thing, Your Honor, is that we had some pictures of the wallpaper, but I haven't been able to show them to Mr. Simpson yet. And the color of the dark blue wallpaper in the entrance hall there that we wanted to present into evidence, and I need to show them to Mr. Simpson. And Joe Alloy is supposed to be here.
Have you seen it?
Yeah, I haven't seen it.
I've seen the wallpaper. I'll let you bring it in out of order. It doesn't make any difference.
Okay, thank you, sir.
Are we ready to proceed on the next motion?
That's all they got.
That was all I was going to call Mr. Alloy for, yes, sir.
And then that's all the testimony on the motion to suppress with the exception of the measure from Mr. Allo and part of the wallpaper.
And the wallpaper, the color of the wallpaper.
All right.
As soon as I get those photos, I'll show them to Mr. Simpson, see if he has any objection.
All right. I will, on the motion to suppress the testimony of Anita Neary, the court has heard the testimony and will hear argument on it at the close of the motion to suppress testimony from Ogden, Utah, I guess, is next one you're going into?
Yes, sir. It's Granger, Utah.
Granger, Utah, wherever it's at. I was absent today. They were naming those towns, and I'm not sure. All right. We'll proceed with that motion then.
Judge, I realize that the Utah Supreme Court decision that went up after the trial and the appeal and whatnot is not mandatory on the court, but we certainly feel that it's persuasive authority, and we've got a certified copy of that Utah Supreme Court opinion, and they did consider the fact of this particular search that we're talking about, and we would ask that you consider that as our first item of evidence. Y'all have a copy of that?
Has this case cited?
I don't have the cite in the reporter, Judge.
Filed December 28, 1978, from the Supreme Court of Utah.
That's correct.
Your Honor, is the introduction of the Supreme Court opinion in Utah by way of argument or evidence?
It's probably both, Mr. Bundy.
All right. Well, we'll be heard on its admission or its significance or lack thereof at argument.
I'm sure you can probably argue anything on that is appropriate. The question is, during the course of trial, this court would receive the opinion for whatever weight it might have, and will let you consider the argument on the weight or its applicability.
Certainly. At present, though, I would simply register my objection to its introduction on the grounds that it does not address the legality of the search in question.
All right. Let the record reflect the court will receive it only for the matters alluded to therein, and if it concerns the question of search, I'll hear the argument as it relates to its conflict argument concerning the concept of whether it's res judicata or not.
That's all we want to do, Judge. Bob Hayward.
Madam Clerk, I want this marked, and then we will make a copy of that. Opinion, if you will.
Let's take Exhibit 1 on this note and move on.
Come right over here, please, sir. Step up to the witness box and raise your right hand.
And do you solemnly swear that the testimony you will give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Be seated.
And
May I proceed?
thank you, Judge. And state your full name, please, sir.
Robert Hayward,
Occupation,
just Utah State Highway Patrol,
and how long have you been so employed?
26 years.
Do you hold a rank with the patrol?
Sergeant.
Directing your attention back to August 16th, 1975. Do you recall being on duty on that day?
Yes, sir, I was.
Specifically at 2:30 in the morning that day?
Yes, sir.
Do you recall pursuing any vehicle at that time?
Yes, sir, I did.
Would you just tell the court in your own words the circumstances surrounding that situation?
Yes, I was stopped in front of my house at approximately 20 minutes to 3 a.m. on that morning. A light-colored Volkswagen went by my car there. Several minutes later, I went to assist the Salt Lake County Sheriff's Office on some juvenile drinking problem. I went around the street, and as I turned the street in back of my house, I threw the lights on bright. The Volkswagen took off at a high rate of speed with no lights on.
Your Honor, at this point, I think it's appropriate to interpose an objection. The testimony that the officer may give at this point we would hold to be immaterial and irrelevant to the issue of whether the search was legal, and that the circumstances preceding the stop of the vehicle do not, in this instance, reflect on whether or not the intrusion into my vehicle was legal under the Constitution.
No objection, we'll overrule it. The question of establishment of probable cause, if it has no relevancy, I'll stop.
Your Honor, we would stipulate at this point to sufficient cause to stop the car. The issue is what happened after the car was stopped.
If that's part of the probable cause, I will allow him to proceed, even though the stipulation. Go ahead.
Okay. I gave chase on the Volkswagen, and this went for several blocks through stop signs. Through the subdivision 40, 45, through 2 stop signs, and then out onto a main road where the vehicle pulled over and stopped in an abandoned gas station.
Okay.
At that time, I approached the driver, and he got out and came back, and we met approximately at the back end of the Volkswagen.
I think you'd recognize the driver if you saw him again?
Yes, sir, I would.
See him anywhere in the courtroom today?
Yes.
Where is he?
That's the man right there with the pencil in his mouth.
With the what?
Pencil in his mouth.
We have a stipulation on it.
Mr. Bundy.
We'd have a difficult time if you removed the pen. If you can name, point him out.
That's the man with the blue shirt on, the coat.
All right, fine.
No, it was Theodore Robert Bundy.
Theodore Robert Bundy.
What happened next?
I asked Mr. Bundy what he was doing in the neighborhood, and he stated that he was lost. And I asked him where he had been, and he stated to a drive-in movie west of where we was, about 3 or 4 miles. He stated he had been seeing the Towering Inferno at that theater, which I'd been patrolling that area most of the night, and that was not the movie that was playing there at all. So anyway, I asked him to step back between the cars. There was 2 other troopers there.
Where were they?
They just pulled up in their car and was sitting there in their car.
They're still in the car?
Yeah.
Any show of weapons at this point?
None at all.
Okay.
I asked the other officers there if they would just watch him for a minute, and I looked in Mr. Bundy's car with my flashlight.
Any part of your body break in the window or anywhere to get it to see in there?
No.
Did you remain outside the car and looking inside?
Yes, sir, I did. I looked in, the passenger seat was not in there. And just looking through in the car, the passenger seat was out and laying on its side in the back seat, which was very peculiar to me. So I walked back to Mr. Bundy and asked him if I could look in his car. And he said, go ahead.
His exact words?
Go ahead.
Okay. What happened next?
So I went back to the passenger side, opened the car door, and looked in his car.
What'd you find?
In back of the driver's seat, there was a small crowbar-looking affair, probably 12, 14 inches long. The passenger seat was laying on the side in the back seat, and alongside of the driver's seat was a small satchel. That satchel was open, and I looked in there, and I found a ski mask. And
What kind of a ski mask?
just a net pulled down over the head type ski mask, standard for what we have in Utah.
Made out of wool?
Yes.
Okay. What else?
And there was some rope and an ice pick and some pantyhose.
What kind of pantyhose? Anything unusual about them?
The pantyhose had holes in them.
Where?
I don't know how to describe it. There were just some holes cut in them. And some other items in there. I wrote them down. A large plastic bag in there. I don't know. That was in there.
Okay, we're not really interested in the other items. We're specifically interested in the pantyhose. If you can give us have you ever seen what's sometimes called a pantyhose mask?
I have, yes.
Is this the type of holes you're talking about?
That would be it.
Would that be consistent with the description of it you've given us?
Yes, sir. It was small, and I did pick it up and look at it, and it had holes in it, side
You
by
better more
side.
fully describe that. I would interpose an objection for the defendant at this time. I understand he's serving his own counsel. You missed that one, my friend, but we'll catch them together, all right? Go ahead. Let's restate that consistent with the way it ought to be.
Let me see if I can make it real clear, Judge. You have this marked, Madam Clerk. This is number what?
185.
Show you what's been marked as State's Exhibit number 1A for identification. Ask you if you can identify that picture.
That would look exactly or very, very similar to the pantyhose that night.
All right. As you see it there, has it been changed in any fashion from the way you saw it that night?
None to my knowledge.
We'd move it into evidence.
For the purpose of the motion, Your Honor, no objection.
Be received without objection.
So that I understand, is this a fair and accurate representation of the pantyhose mask you saw in Utah?
It is.
All right. Judge. During the time that you were looking in the car and looking in that specific satchel, at any point did Mr. Bundy object to that search that was ongoing?
No, sir.
Describe for the court, if you will, the scope of your authority at that time with the law enforcement agency.
We, in the state of Utah, work, the Highway Patrol works straight traffic, very, very little criminal. And if and when we do confront any criminal activity, we'd immediately call Salt Lake County or the city or wherever we might be working at that time to handle any criminal actions.
All right. Is a Utah State Trooper, as a general situation, authorized to make arrests throughout the state of Utah?
Throughout the state of Utah, yes.
And what county did this occur in?
Salt Lake County.
What city generally?
Granger.
Who else arrived at the scene? You said 2 troopers were there. How long did it take for them to arrive on the scene?
Just a matter of 2 or 3 minutes, and he was there.
Who else arrived after that? Anybody?
I called the sheriff's office and asked for a detective car. 2 uniformed officers showed and stood by, and then Deputy Detective Ondrack, Daryl Ondrack from the county sheriff's office arrived on the scene.
That's all I have, Judge.
And Cross?
Yes, Your Honor. Is that Sergeant Hayward now? Sergeant Hayward, did you prepare a report based upon the stop and the search that you just testified to?
Did I prepare a report?
A written report, yes. Did you have it with you?
We have what we call an incident report that we make out.
Objection to the use of the report as evidence.
You haven't used it as evidence yet.
That he may do it. Hasn't been offered yet.
Thank you. Did you review that report before coming here today?
You bet.
Did you have anything else that you used in preparing for your testimony today by way of refreshing your memory?
Just my reports.
Reports? Is there another report?
Yeah, right here on the back of this, I jot little notes down on the back of things.
May I see that, please?
Yes, sir.
I noticed, Sergeant, that you also have a booking photograph in front of you.
A what?
A photograph in front of you. Would you mind if you could identify whose photograph that is?
That's you, Theodore Robert Bundy.
going back to your incident report, when was that written, if I might ask, please?
Just shortly after the incident. See, this was written and filled out on October 14th.
And, officer, if there's a conflict between your testimony today and the contents of the report, which would be more accurate?
Jackson, there's been no such situation. There's been no statement of inaccuracy. If you have some discrepancies in there, question him first on the discrepancy, and then you...
Sergeant Hayward, let's begin with the stop of my vehicle on August the 15th. Would you please tell me what happened after you pulled the Volkswagen over in Granger? What happened? What did you do, and what did the occupant, what did I do?
You stepped out of your Volkswagen, and as I stepped out of the patrol car, and we met approximately at the rear of your Volkswagen.
Please describe the vicinity where you had stopped the Volkswagen, the type of neighborhood, the type of area that the stop occurred in.
There was an abandoned gas station.
Abandoned gas station. Describe the lighting in the vicinity, or in that particular spot where you stopped the Volkswagen. Was it bright? Was it dim? Was it dark?
Well, there's some lights in the area. I wouldn't call it exceptionally light.
What time of day was it?
Pardon?
What time of day was it?
This was approximately 2:45 a.m.
And was it dark out?
Yes, it was.
Was there a lot of traffic on the road at that time?
Not too bad, no.
How would you describe the traffic conditions in the vicinity on the street where you stopped the Volkswagen? A lot of traffic, very little traffic, no traffic?
Little traffic that time of the morning.
All right, what was the first question, or what was the first thing you said to me when you got out of your car?
I asked for your driver's license and registration.
Do you remember a comment you made previous to that? Previous to asking me for my driver's license?
No, I can't recall one.
Do you remember whether or not you told me that I should have got out and run, that you could have taken my head off? Do you remember saying that? Prior to asking me for my driver's license, do you remember saying something to the effect that I should have gotten out and run, you could have taken my head off?
No, sir, I don't recall that.
You don't recall that?
No.
And what did I do after you requested the driver's license?
You give me a driver's license and registration of the vehicle.
And what did you do?
I read them and asked if that's still where you lived and resided on the avenue, and you said yes.
Were there other officers on the scene at that time? The time I gave you my driver's license?
I'm not sure they was there right then or shortly after.
And was there anybody with me in the Volkswagen?
No, you were alone.
And before I forget to ask the $64,000 question, did you have a search warrant to search my car?
No, sir.
After you verified that the address was current, that you had a current Utah driver's license from me, what did you do, officer?
I placed you by my right front fender and asked the other officer to watch you for a minute while I flashed a light in your car. But
Now, you asked another officer to watch me?
Mm-hmm.
You remember the name of that officer?
There was, one was named Brent Fowles.
What was the purpose of asking that officer to watch me?
Would you believe I didn't trust you?
You didn't want me to run away, is that what you're saying?
Probably.
Was I free to leave at that point?
I would doubt that.
Was I in, well, the alternative, was I in custody at that point? Your custody?
No.
Yeah, you placed me in the, hesitate to use the word custody. You told Officer Fowles to watch me, and then you did what?
I went back and shined a light in your car.
What kind of light?
Flashlight.
You would describe to me where you shine the light, where you first used the light, how you examined the car with the flashlight.
Yeah, I just shined a light in the windows and took a look at what I could see from the window. The crowbar and the seat in the back. The passenger seat was on the back seat, and I could see that through the windows.
What window did you start with first? The rear window, the passenger side window, the driver's side window, do you recall?
It seemed like I was on the driver's side window first, and when I placed you back by the fender, I went back on the passenger side window.
And you shone your flashlight inside the car, and could you describe to me as much detail as you can recall exactly what you saw and in what order, if you can recall, what you saw?
I saw a small crowbar behind your seat on the floor, and I saw the passenger seat in the back seat on its side, and a small satchel along the side of the driver's seat.
You see a small satchel on the side of the driver's seat. What side of the driver's seat? Left or right? On the right side?
Right-hand side.
Describe to me the satchel as you saw it.
Well, it wasn't a big one. It was probably maybe 14, 15 inches long, and it was more small and round. What do you, 6 or 8 inches in depth, something similar to that.
What color was it?
I'm thinking it was kind of a brownish color.
Have you seen that brown satchel since the stop on August the 15th?
No, I have not.
All right. What else do you recall about the satchel? When you were shining the flashlight into the car and looking at the contents of the interior of the car?
You must miss me on that. Would you ask that again?
Oh. We've got you shining the flashlight in, let's say, the passenger side window. Is that where you saw first recognized the brown satchel when you're shining your flashlight in there? Now, what you've described as being a satchel about so big and so deep, the testimony reflects it's round. What else was there about it?
It was open.
And what did you see inside?
Well, after I got permission from you to go inside.
At that time, with the flashlight?
That's all I saw.
Just the brown satchel? Is that correct? Just the satchel?
That's right.
Let's back up just a little bit, and I want to make sure that you are able to relate as much detail as possible the conversations that transpired between yourself and me. Now, we had a discussion, according to your testimony, about the driver's license. Is that correct? Is it also your testimony that the discussion about my whereabouts took place in the early, just after I was stopped?
Yes, sir.
Now, what was your question when you wanted to know? You can recall the exact question you asked me.
I asked you what you were doing in the neighborhood.
Is that the question you asked?
Mm-hmm.
As nearly as you can remember?
What was you doing in my neighborhood? Is that better?
That sounds, we're getting there, officer. Is that better? Or is that closer to what you remember saying? What were you doing in my neighborhood?
Objection, argument with the witness.
Don't argue with it.
I'm not trying. Would it help you to refresh your recollection with any of your reports?
I don't have the exact wording down here either.
Now, what, if you can recall, was the next thing you said to me or that I said to you after we had the discussion? Well, pardon me, let's back up to the question you asked, what are you doing in my neighborhood, okay? What was my response, according to you?
You was lost.
Did I say anything else?
Not to my recollection.
At that time, I didn't say anything else to your recollection.
You said, well, you was lost.
And what else did, if anything, did we discuss at that time that you can remember? Questions that you might have asked, for example.
I asked where you had been, and you told me that the drive-in theater, seeing the Towering Inferno.
That occurred about the same time in the stream of events we're talking about?
Probably a couple, 2 or 3 things there.
Okay. Was that before you started shining your flashlight in the windows?
That was before.
Now, were you familiar with any drive-in theater in the neighborhood?
Yes, I am.
Did you know whether or not the drive-in movie was playing there?
Yes, I did.
At that time?
Yes, sir.
What did you know?
I sent the one trooper back out to check the marquee.
When did you send him out?
While we were still there or immediately following.
So you didn't know for sure that that movie was not playing there at that time? That's what I'm getting at. Is that true or not?
No, I was sure, but to make positive in my own mind, I'd been patrolling that movie in that area most of that night.
Okay, what's the next thing or question that you asked or a response that I gave you prior to the time that you started examining the interior of the car with your flashlight? Is there anything else you said to me?
Not that I recall.
Anything else I said to you?
Before I
Left me at the rear or the front of your car with Officer Fowles and you began examining the car. Anything else you can recall?
No, the only recall is I asked you if you'd stand by my right front fender.
Let's return now to your process of looking in the car with your flashlight. You've described the crowbar, seat being out, and the satchel. Is there anything else in the interior of the car that caught your attention?
The missing seat, the crowbar, and the satchel were the main things that I saw.
Okay. What did you do after you completed your looking in the car?
That's when I called for a detective car from the county.
Okay. And how did you summon the detective car?
By radio.
Why did you summon it?
Sustained objection. No, that's not considered why we summoned.
You summoned it by radio?
Yes.
And this was it a Salt Lake County Sheriff's detective that you summoned?
Yes, sir.
Do you know the name of the officer? Did you call for a specific detective?
No, I just asked for a detective car.
Well, after you told me to stand by the front of your car with Officer Fowles, when was the next time you had occasion to talk to me or ask me a question?
When
Chronologically, when was the next time you asked me anything or I talked to you?
When I come back to ask you if I could look in your car.
Okay, now I want you. When did you come back to ask me that question? When? Again, we're proceeding is step by step through this procedure. In point of time, when did you approach me to ask me that question?
I looked in your passenger side windows and seen these things, and I come back and asked you if I could look in your car.
Now, is that an accurate representation of what you said to me at that time?
Objection, arguing with the witness.
To the best of your recollection, then you asked me if you could look at my car.
Same objection.
Was there any response from me?
Yes.
And to the best of your recollection, and I want you to try to recall, with the aid of your reports if necessary, the exact words that you recall me saying to you in response to that question.
Go ahead. That was your words to me.
Is Officer Fowle still with me?
No.
Were there any other officers still at the scene?
No, when the deputies got there, the other officers left.
Yeah, there were deputies there now. At the time you asked me, can I look in your car, what police officers were on the scene? How many were there and where were they from, if you can recall?
There was 2 state troopers when I asked you that.
Were they standing within earshot? Could they hear what you said?
I don't.
If he knows.
If you know.
Yeah.
I don't believe so. In fact, they were both sitting in a car.
And when you asked me that question, where was I standing?
By my right front fender.
I was still where you told me to go, is that right?
Right.
After that exchange, Officer Hayward, what did you do?
After I asked you if I could look in your car, then I went back and opened the passenger side door and looked in your car.
You looked in it?
Yes, sir.
And where did you search the car, officer?
I looked at the seat, the crowbar, and I looked in the satchel.
You looked in the satchel. And how did you examine the satchel? Exactly what did you do with the satchel?
The satchel was open a few inches, and I looked in it, and I picked a few things out and looked in it with a flashlight.
You had a flashlight with you? And can you give me a detailed description of the items you saw in the satchel?
Let's see.
You're refreshing.
With a rope, a piece of rope, some wire, an ice pick, plastic bag, ski mask, silk stocking. That's what I got down as being the contents of your satchel.
Did you notice anything peculiar at that time about, if there was anything peculiar at that time about the, quote, silk stocking, close quote?
Just that it had holes in it.
Look at the picture. Thank you. Did you do anything special with the stocking?
Did I?
Yes.
No, I didn't.
How did you determine there were holes in it? You just happened to see holes in it?
Just looked at it. I didn't examine it or anything in there closely.
Have you seen that stocking since August the 15th, 1975?
Objection, irrelevant.
Have you seen that stocking that you saw in the brown satchel since August the 15th, 1975?
Yes.
Where?
Here.
In this courtroom?
No, in an evidence bag.
Can you look at this photograph marked as State's Exhibit number 2 and tell me whether or not that is for sure the same silk stocking that you saw in the brown satchel on the date in question?
I'll say it's similar.
Did you place any initials or anything on that, on the silk stocking itself?
No, sir, when I run into that stuff, that's when I call to look for Detective Carr.
So you called for the detective car after you made the initial intrusion into the vehicle. Then at that time, is that when you decided to call the detective car?
Yes, sir.
What had you stopped me for on the morning of August 15th, 1975?
What did I stop you for?
Yes.
Failure to stop for the command of police officer.
And in Utah, what kind of offense is that?
Indictable misdemeanor.
Indictable misdemeanor. You finished, well, let's get back to what you were doing inside the car. You just testified a few minutes ago that you examined the contents of the satchel.
Yes, sir.
What else, where did you go in the car next to search, if anywhere?
I didn't.
What did you do?
I came back and called for the county detective car.
You used your police car radio to call?
Yes, sir.
Did you have any conversation with me just prior to or after calling the detective's car?
After the detective car was called, and if I recall right, I didn't write that down, I placed you under arrest.
That time I was placed under arrest?
I believe they was there then.
Under what charge? For what
Evading.
How did you place me under arrest?
Objection, irrelevant.
What did you say to me?
Pardon?
What did you say to me? You said you placed me under arrest. Was there a communication by you to me that you placed me under arrest?
Objection, irrelevant. Getting a little bit past the search now, Judge.
Well,
being tied up, I don't have
Search preceded the arrest, Mr. Bundy, is supposed based on testimony I've heard.
but it did not precede the seizure, Your Honor.
All right, so you tied it up. Go ahead.
Let me get this from you. Sergeant, did you take into your possession at the time you initially entered the car, any of the items in the car?
I did not.
Okay, so you hadn't seized anything from the car at that time, had you? You hadn't seized any of the items you saw in my Volkswagen, did you?
No, sir.
At the time you placed me under arrest, how long had it been since the initial stop had occurred?
Just want a ballpark figure?
The best estimate you can give us.
$15 minutes, something to that effect.
Your Honor, could we approach the bench on an earlier question?
You want to report?
Yes, please.
Come on, Tom.
stated earlier that you placed me under arrest, and I'd like to ask the question again. How did you go about placing me under arrest?
I told you you was under arrest for evading a police officer. I stripped you and handcuffed you and placed you in my car.
Is that all?
Yes.
Immediately placed me in my car, or your car, excuse me.
I placed you in my car. Right.
Subsequent to placing me in my car, your car, did the sheriff's detective arrive?
Yeah, they was there.
And what happened when the sheriff's detective arrived? Let me ask you this. Who was the sheriff's detective who arrived on the scene?
Deputy Andrak.
And what happened when he arrived?
He looked at paraphernalia, the tools and the different things in there, and he confiscated and brought everything back. And I remember you and him telling you what he was going to do. He was going to take everything out of your car, and if it constituted that the county attorney would give him a complaint for possession of burglary tools, that he would get the complaint and be in contact in the next couple of days.
Recall any remarks, if any, were made from me in response to that?
You said something to the effect that that's fine.
You think is that what you, I hear you say you thought I said something like that? You recall that remark being made is what I'm asking you, or is it something you thought it might have been said?
By the deputy or you?
By me.
No, you said that.
Officer, after you had examined the interior of my car on that occasion with your flashlight, your testimony is you went back and asked me, quote, "Can I look in your car?"
Objection, repetitious.
What I'm trying to do...
It is repetition. Please state your question.
Certainly. My question is, Officer Hayward, can you recall what the reason was that you asked that question of me? Why did you come back and ask me that question?
If I look irrelevant. Why he asked it?
Why ask?
It is irrelevant. I don't know why he might have asked it. It's a question of its legal impact. His particular reason for asking the question is not significant, Mr. Bundy, as his compliance with the law. He might simply have been curious. He might have been a lot of things. Those things I don't think are probative. It's a question of fact for the court to determine the impact of the question, not why a particular police officer asked.
If I might be heard on that point, and I don't think it needs to be set out of the hearing of the witness, isn't it also an issue, Your Honor, of the knowledge, facts, and circumstances within the knowledge of the officer who initiates the search as to whether or not he had justification?
Well, his subjective justification is not the measure, Mr. Bundy. It's the objective interpretations as held by the court based upon his actions and what was said. That's the reason for it.
Did you say anything to Officer Andrak when he arrived on the scene concerning the vehicle and the subject you had in custody? Did you say anything to him?
I can't recall a specific conversation. I must have pointed out these different items.
Is there anything in your report or reports that would refresh your memory?
No, I have nothing in there of conversations. with Deputy Andre.
Did the search continue after I was placed under arrest? The search of my car, did it continue after you placed me in your vehicle?
I believe it went on.
What areas of the car were searched?
Objection, Your Honor.
I'll let it be.
What areas of the car were searched?
It seems there was the two officers that were in uniform.
Right here is not just that very narrow finding of the Supreme Court in the Bustamante case, but a very enlightening discussion that proceeds just a page or so prior to the ruling of the court, a discussion that involves custodial versus non-custodial situations. And the court in the Sneckroth case, it seems to me, took some pains to labor over the distinction between custodial interrogation as it involves Miranda, as it might be distinguished from non-custodial situations where a person is asked for a consent to search and no advisement is given. And if the court will give me a moment, it's a long opinion. I don't have my marked copy here. I've got a larger copy. But in essence, I think what the Bustamante court was saying was that we have inherent in the custodial situation and custodial circumstances potential for coercion. And that, of course, is the very reason why the court in Miranda required the defendant be read his rights, his right to remain silent, right to counsel, and so on, and that is an absolute right, and that right is that of every suspect in custody who is being interrogated. And the analogy, or the distinction, as it were, between Bustamante and the facts of this case is that it's clear that I was in custody, that I was not free to leave. I think the facts of this case show that I was being questioned and otherwise interrogated by police officers prior to a reading of any Miranda advisement. And what we see here is the beginning of a course of conduct on the part of officers at the scene in this search, whereby there was a systematic avoidance of taking into consideration not only the Fifth Amendment, but the Fourth Amendment. It's the testimony of Sergeant Hayward that he did not read me my Miranda rights prior to his initial search, that he did not advise me that I had a right to refuse consent to search my car if such a request to consent had been made. And I think I know that what I'm asking the court now is to distinguish this case from the Bustamante case on the basis of custody versus non-custody, and then examine, as all the case law requires, examine all the circumstances surrounding the search which have been brought forth through testimony heard by the court, to examine the totality of the circumstances.
Have you read Watson since Bustamante?
I recall seeing the case, but I can't say that I've read it, Your Honor.
All right, go ahead.
based upon my analysis of the circumstances surrounding the alleged consent, there are these circumstances which I say weigh against finding that the consent was freely, voluntarily, and knowingly given, and which would detract from any attempt by the state to prove by whatever burden they have to prove it that such a consent was legally obtained. The first would be, as it's been demonstrated, that there was no Miranda warning prior to the alleged request for the search or the actual search. Now, certainly, the law is clear that no such warning is required, but it is one of the factors that courts have looked to. It's one of the factors, one of the circumstances. The second would be the lack of advisement that I had a right to refuse the consent to the search. And I think that has been brought out in testimony this afternoon. The third factor, which courts look to and have placed a considerable amount of, paid a considerable amount of attention to, is the attitude of the police and the circumstances which would indicate that the person, the defendant, the person in custody, was subject to coercion or intimidation. There's some conflict in the record as to whether the police were hostile or not. It's my testimony versus the officer's testimony. And yet, I think even if one tries to take a middle line and just accepts the facts which are not in conflict, it is clear that I was stopped at an early hour of the morning, that I was alone, I was surrounded by a number of police officers, I was told to go places, and I went places. I was in custody. I was being, again, questioned in the absence of Miranda, and questioned in such a fashion as indicated to me that the police were very upset about the circumstances of the stop. The fourth factor that I think is really important here is something the state will dwell on, and something that I'm going to pay a great deal of attention to, and that's my failure to object, which I have admitted to and testified to. And indeed, I did not object to the search. And my explanation for my failure to object is, and was, and my feelings are the same now as they were then, that when confronted with a number of police officers who I believed to be making demands of me and telling me what to do and where to go and questioning me in the way they were questioning me, and that alone at that hour of the morning, that I really had no control of the situation, and not knowing, and I did not know, that I had a right to refuse any intrusion into my automobile, then I really felt I couldn't stop them from doing what they were doing. And that is in fact my testimony, and that is in fact, that's my testimony. The fifth factor is something that I want to make as clear as I can, because it deals with the manner in which the alleged request for a consent was made. The officer's testimony is that he had that flashlight, and he was looking, he said he looked in the car. He looked in that car with the flashlight, and then, after seeing what he saw in there, came back to me and said, "Can I look in your car?" Well, he had been looking in my car. And I don't want to split hairs, Your Honor, but if a trained police officer is going to request to search a vehicle with such ambiguous terms as look in your car, in the same way he describes as a visual looking in the car with a flashlight, to me it fails to meet the requirement of law that a request for a waiver of a constitutional right be express and be clear and be concise. There was no request for a consent search, let alone an advisement of that I had the right to refuse any such request. The officer did not say, "May I search your car? May I enter your car and search your car?" or any words that were clear, concise, and explicit. The best we have, if one believes the police officer, is that he said, "Can I look in your car?" And the best he can come up with is that my response was, "Go ahead." And if you believe the police officer, he believed that to be a valid waiver of my Fourth Amendment right, if such a conversation took place. I believe that neither the request nor the reply was sufficiently explicit or expressive or intelligibly given to constitute a knowing waiver. So it's my position that the search of the vehicle on August the 16th, 1975 did not occur pursuant to a valid consent. It's also my position that the state cannot rely on any plain view doctrine. In other words, it's the officer's testimony that he looked in the car and he couldn't put it all together, so he went back there. Obviously, what he saw in the car was not, in his own mind, sufficient to cause him to enter that car, believing he had probable cause. I don't think we have any probable cause argument left to the state here. They've got to ride on consent, or they don't go at all.
You object to the search or the seizure, or both?
Well, here is where we're going. Florida law is clear, and I think by the very nature of the term search and seizure, it is clear that we're talking about two terms that are not synonymous. The process of search and seizure, by its very definition, is a bifurcated process. And because, let's say there's probable cause to search, or there is some exception to the warrant requirement that puts an officer in a position to be in a protected area, does not mean there is probable cause to seize. And this is what I was trying to get at when I was questioning Officer Andrak before, and that is, there must be probable cause to seize, based upon the facts, the circumstances, and the information within the knowledge of that officer and what the court, of course, would believe that a prudent person under those circumstances would do. Even if, of course we're saying the consent did not occur, but even if Detective Andrak was legitimately in the position to enter that car and to search it, my argument is that he did not have probable cause to seize for these reasons, which I was able to bring out to a certain degree. That he knew nothing of any burglaries in the area. He did not know whether or not I had any criminal record.
Possession per se was not a crime.
Well, the possession of contraband or possession of burglary tools infers that the officer had to believe that there was an intent to use those, unless they had information in his own knowledge, facts within his own knowledge, that led him to gave him probable cause to believe there was an intent to use those, or those articles had been used as burglary tools. Now, I'm not trying to I can read to you the Utah statute on burglary tools, but of course we're not holding the officer to the knowledge of a legal technician, but we do impose upon Officer Andrak the knowledge of a prudent and reasonable man, and we have to say, what did Officer Andrak know at the time he seized those things? He knew I'd been stopped, but he testified he didn't really know for what. He knew I was in custody, but not sure what I was in custody for. Didn't know anything about any burglaries in the area. There was nothing that indicated to him I fit the description of a burglar. There was nothing that indicated to him that I had a history of burglary. So I think the rule here is, are the articles seized from my car capable of lawful use as well as unlawful use? But beyond that, do they constitute in and of themselves burglary tools for which they could be seized? Was there probable cause to seize them? The officer's testimony is that under the rubric of the burglary tool statute, he seized a pair of handcuffs. Pardon me, burglary tools, or handcuffs, are per se tools which cannot be used in the course of a burglary. If you use handcuffs, it seems to me that it becomes a robbery by its very nature.
Did Detective Pottinger ever ask you what significance you attached to photograph number 7 during the course of this photographic spread?
I don't remember.
Did Detective Pottinger do anything to either photograph 4 or 7 to point out any similarity in the assailant?
No, he did not.
Question, did Captain Pottinger do that?
Yeah.
All right.
Did he do anything to allow you to ascertain a closer resemblance of either photograph 4 or 7?
Would you repeat the question, please?
Yes.
Or expand on it? I'm not sure I understand.
Well, did Captain Pottinger do anything in order to aid you in ascertaining whether there was a closer resemblance of either photograph 7 or 4?
No.
Did he take the photograph, either photograph, and place his hand on either photograph?
Yes, he did.
Which photograph?
There were 2 photographs at the time. I ruled out one, and there was only one left. I didn't compare them.
Was there only one photograph that he placed his hand on?
Yes.
Did he ask you for an opinion as to the quality of your recognition?
No.
Did he give you a choice between whether you were definite or whether there was a striking resemblance
Yes,
of
he
photograph? Pardon?
Yes.
Did he give you any other choices?
No.
Do you remember saying that you didn't know whether it was definite or there was a striking resemblance?
Judge, we'll have to lay the credit.
Only her recollection, and then you may answer the question.
I don't remember.
Now you may proceed.
Do you remember Detective Pottinger saying, okay, do you feel definitely that this is the person, or do you feel that there is a striking resemblance?
Yes, I do.
And your answer was, I don't know. A pretty definite resemblance. Do you remember that?
Yes, I do.
Now, what did you mean by I don't know?
I think she's going to have to answer it in terms of the entire
Well,
answer.
But I think she can answer it in the way that the question's asked.
What did you mean by I don't know?
I don't know. I thought there was a very strong resemblance.
Now, you said a pretty definite resemblance.
Well, if you want to...
I think the answer on the question was very definite resemblance.
What did you mean by the portion of your answer that said I don't know?
She answered that, counsel.
Did Detective Pottinger tell you who any of the other photographs were?
No, he did not.
Do you have an independent recollection of your familiarity with any of the features that appeared in the newspaper photographs compared to the features that appear in the photo number 4 in the photo lineup?
Objection. We've been through that. I think we've answered that, Mr. Hager.
Did there come a time that you returned to Tallahassee around July 27th for a grand jury?
Yes.
Tell me when you arrived.
I don't remember the exact time we came in. I think it might have been late morning. I'm not sure. I've come down here so many times, I'm not sure.
And when was the grand jury hearing?
The date?
Well, relative to your arrival.
Oh, I don't remember. I think it was, later on that day.
Was it in the afternoon?
Yes, I believe so.
Did you meet with Mr. Simpson prior to going to the grand jury?
Yes, I believe that was the first time I met Mr. Simpson.
And where did you meet with him?
In his office.
And how long did you meet with him in his office?
I don't remember how long, maybe an hour.
And did you discuss what you expected your testimony to be in the grand jury?
Restate the question.
Did you discuss with him the case?
Yes, we discussed mainly the proceedings, what was going to go on in the grand jury. He explained to me that there was no jurors, nothing like that. I had no idea what a grand jury was.
Well, did you discuss with him the events of the early morning of the 15th of January?
Yes, I believe I did.
Did you discuss with him your composite with Mr. Keniston?
I don't remember.
Did you discuss with him the photographs you had seen in the newspaper?
I don't remember.
Did you discuss with him the photo lineup or photo spread that you had done with Detective Pottinger?
Yes.
And, all right, give me the benefit of those discussions.
I explained to him what had happened, exactly how I just explained to you how it was done. And I told Mr. Simpson that I felt that the one picture I picked out, I felt very strong. I had very strong feelings that that was the man that I had seen that night.
All right, did you go over that with the pictures with Mr. Simpson?
No.
Did you see the pictures in his office again?
No.
Did you see Nancy Dowdy prior to going to the grand jury?
I don't remember seeing her prior.
Do you remember her coming to your motel room?
Yes.
What time was that?
I don't remember.
You don't remember that?
No.
You remember whether it was before you went to Mr. Simpson's office?
I don't remember.
Do you remember what you talked about with Nancy Dowdy?
No, we got caught up on some sorority gossip.
No, I'm talking about this case.
No, I don't remember.
Do you remember talking about the description with Nancy Dowdy?
No.
You remember going over the description with her?
Objection.
Do you remember talking about what you had said to Nancy Dowdy as you came upstairs?
Objection, Your Honor.
When is this now, Mr. Simpson?
In the motel room, Your Honor, do you remember discussing with Nancy Dowdy on the morning of, or whenever you met with her at your motel, discussing what you had told to her as you came upstairs on the morning of the 15th of January?
No, I don't remember that.
Did you walk over to the grand jury proceeding with Mr. Simpson?
No.
How did you arrive there?
I believe Mr. Clark took us over.
And what happened when you were called into the grand jury room?
Objection.
What are you talking about? Not her testimony, are you?
Well, insofar as when you were called into the grand jury room, were you shown a photograph?
Objection.
I'll let her answer if she was shown a photograph.
No.
Were you asked to state that you had made an identification for
Sustained.
Mr. Simpson? Your Honor, we would move for the production on it.
I've already ruled on it, counsel. Proceed on.
What reference point did Mr. Simpson use for you to make an identification in the grand
Sustained.
jury room?
You go in that grand jury court one more time, I'm marking this record, and when this case is over, we're gonna have another hearing. All right?
Yes, sir.
As long as we stand each other. Fine, go ahead.
Did you have discussions with Mr. Clark or Mr. Simpson after the grand jury?
No, I did not.
Did there come a time that you later returned to Tallahassee?
Yes.
Between the time you left after the grand jury and the time you returned to Tallahassee, and that was in October, right?
Right.
Did you have any conversations with any detectives or any state attorneys?
As it relates to the case, Your Honor.
No, I don't believe so.
Do you recall what day it was you returned to Tallahassee in October?
As to the exact date, no.
Do you recall when you first met with either an investigator or with Mr. Simpson?
Yes, I do.
When was that?
It was the night before the trial was supposed to start,
And where did you meet with him?
in his office.
And did you go over the case?
Yes, I believe we went over my deposition.
All right. Aside from your deposition, anything else?
No.
Did you?
Let me understand something now. This young lady's deposition has been taken twice, is that correct?
No.
And the deposition that you refer to is the one Mr. Minerva took prior to the October hearing?
No, sir. There's not a deposition prior to October.
Well, that's what I'm concerned with. I was not aware of one. If it was, I want to make sure it was made known to the defendant or to whoever it is, because the court's only recollection is sometime after that. Inquire about that, counsel. The court's concerned with it.
What papers did you look at?
What papers?
Yes, ma'am. What papers did Mr. Simpson show you?
He didn't show me any papers.
Well, there must have been a series of questions and answers. Is that right?
Yes.
whose questions and answers did you look at?
I didn't look at him, he asked me questions.
He asked you questions and answers?
Yes.
Out of papers that he had before him?
Yes.
Would you try to recall as nearly as you can what he asked you and what the answers were that he read to you?
I will let her answer that as trial preparation. Post indictment, trial preparation. Go ahead, so the record's clear.
We went over my deposition. Those were the, we just went over what I had stated before.
Yeah, one moment.
Sure.
What did you go over that you had stated before?
Everything,
And we're limited to identification, go into
Yeah.
that, and I think we'll be closer to it.
What did you go over that you had stated before in respect of Mr. Simpson? With respect to description?
No, I'll let her go into that, identification issues.
we went over the same thing that has been said today and has been said in my deposition.
Well, can you give me some detail as to what you went over with Mr. Simpson? What did he tell you about the description?
Objection, Your
What
Honor.
did he tell her?
Yes.
All right, I'll let her answer that question.
He didn't tell me anything about the description. He was asking questions. I was the one talking about the description.
Well, what questions did he ask you?
Objection, Your Honor. It's repetitious.
Is there any recordation of this document or anything? Any statements given?
You're asking Mr. Simpson?
No, I'm asking you, are you aware of any?
No, I'm not aware of it, Your Honor.
As best you call, you may narrate it.
We went over the exact description as to the details of what the description I have of the man that night. The nose, the lips, the height, the build, everything we've went over today.
Well, when you say everything we went over today, please be specific. Okay?
She wasn't in
Anything else?
Tallahassee a week, she couldn't have gone over everything we've gone over. Get as close as you can to remember, young lady.
The
exactly what
nose, the
transpired.
mouth, the build, the height, the coat, the pants, the ski cap, the position.
Demonstration, did you do a demonstration for Mr. Simpson?
I don't remember doing any demonstration now.
Did you go over the sketch that Mr. Keniston made with Mr. Simpson?
Yes, I was shown the sketch.
All right, what did you tell him about Mr. Simpson showed you the sketch?
Yes.
All right. What was your discussions about the sketches?
The questions that I remember were asked were these, the sketches drawn, which I answered yes, and to me, were they accurate? And I said yes.
What do you mean, were they accurate?
No, I don't know how.
I'll sustain that.
Mr. Simpson asked you if they were accurate?
Objection, that's what she said, Your Honor.
Repetitious.
Did he attempt to distinguish the sketches,
Objection.
one from another?
Objection.
I'll let her answer.
No.
Did he ask you to compare the sketches to the assailant?
He asked me if they were a fair drawing.
Did he ask you if the sketches resembled Mr. Bundy?
Objection.
Sustain. If you want to find out if they ask any other question about the sketches, I'll let you know.
What else did you discuss with Mr. Simpson about the sketches?
That's about it.
Try to search your memory.
Objection.
let me know if that's about it or if that is it.
I'll let him, if you have any other recollection, young lady?
No, I do not.
All right.
Did you discuss the newspaper photographs with Mr. Simpson?
Objection, she's already testified that.
I think she did, Counsel.
Did he show you any newspaper articles?
No, he did not.
Did he show you the photographs that you would be expected to select at a trial?
No, he did not.
Who else was present besides Mr. Simpson and yourself?
No one.
And how long did this preparation for trial take?
Objection.
So a period of time were they there?
Yes, Your Honor.
She was there.
What period of time were you there with Mr. Simpson?
I believe I answered that before. I approximated an hour.
I don't think I heard that. What did you say?
I thought I answered that before an hour.
You might have. I missed it. About an hour?
Yes,
Thank you.
approximately.
Thank you.
Did you render any opinion to Mr. Simpson relative to the identification during that hour?
I told you I felt strong about the photograph.
Is that what you told Mr. Simpson?
Yes.
Did you tell him anything else along those lines?
Not that I remember.
Did Mr. Simpson ask you about the other photograph that you had taken out?
No, he did not.
The next morning, did you meet Mr. Simpson or someone from Mr. Simpson's office at the courthouse?
No.
How did you arrive at the courthouse?
We drove to the courthouse with Mr. Clark,
Who's Mr. Clark?
an officer.
With whom? With whose office?
I'm not sure. Maybe the sheriff's department. I'm not sure which department.
Was he uniformed or ununiformed?
He was ununiformed at the time.
And Mr. Clark took you where? From your hotel to the court?
Yes.
Did you discuss the case with Mr. Clark?
Objection. Irrelevant.
Sustained.
Did you discuss anything relating to the assailant with Mr. Clark?
Not that I remember.
And tell me what happened when you arrived at the courthouse with Mr. Clark.
We waited, and then my mother and I were seated in the courtroom, and we waited for it to begin.
All right. At what time did you arrive? In the courtroom.
Sustained.
Where were you seated in the courtroom?
I believe facing the judge, the second bench back on the right-hand side.
And did you arrive before or after proceedings had begun?
Before.
Before? Were there any other prospective witnesses there also?
Yes, there was.
Who was there that you knew?
Objection. Terri.
On identification concept, I'm going to sustain it.
Who did you speak with?
Objection.
Same rule.
What happened when court began?
Objection.
We're a little bit overbroad, Mr. Haggard, the issue, of course, is identification. And anything about that you may go into, but
Did anyone come into the courtroom aside from the judge and bail and court personnel after the court began?
Objection.
well, I'll let her answer that. But you can be a little more direct than that, Mr. Haggard. I'm sure Mr. Weatherington and quite a few people up there this court has met, were in and out of that courtroom. Question is, did the defendant come in, young lady?
Yes.
And where did he come into the courtroom from?
I don't remember exactly.
What was he wearing?
He was wearing a light blue jacket, I believe, and I don't know what pants.
From where did you see him in the courtroom when he entered?
Your Honor, she didn't say she saw him in.
I'll let her answer that.
I saw him from behind.
Was he standing or seated?
Both.
How long did you have to observe him?
I don't remember how long I was in there, but I did not stare at him the whole time.
Well, give us your best estimate of how long you were there when he was there.
Probably half an hour.
And during this half hour, what was happening in court?
They were trying to get the case delayed because of certain motions.
What's commonly called a motion for continuance?
Objection.
And who was arguing the motion for continuance or delay?
Mr. Bundy.
And where was he standing relative to your seat when he was arguing the motion?
He was in front of me, a little to my left.
A little to your left? Could you maybe, let's assume you were seated back here in the second row, perhaps where that lady in the blue shirt is seated. Where would Mr. Bundy have been?
I'm sorry, I don't know what lady you're talking about.
It's a pretty lady here in the blue shirt.
They're all pretty, Mr. Haggard.
I've learned that, Judge.
Keep that in mind.
Relative to her, where would Mr.
I'm sorry, I still don't know which one you mean.
This lady here, hold up your hand here. You hold up your hand. This lady, did you see her? Yes. Where would Mr. Bundy have been?
I'm just a little bit further.
Tell me where to go. I know you probably like
It's probably to the seat next to him.
about here. Would this be a fair approximation?
Yes.
Difficult to reproduce this for the record, Your Honor. Indicating about 12 feet and maybe an angle of 20 degrees.
Looks like it's a little farther than that to me, Your Honor.
I'll go 15.
I can take 20.
17 and a half feet. It's somewhere between 15 and 20, let the record reflect it.
And how long, you say he was doing this motion for about half hour?
Approximately.
And did you have an opportunity to observe his facial features?
Yes, I did.
Did you recognize him in the courtroom?
In what regard?
I modify your question, you may proceed with.
Well,
Question.
did you recognize him as the assailant?
I didn't get the exact profile that I had gotten that night. I recognized him to look like the man I saw in the picture, but again, it was not that exact profile as I had seen in the picture.
To look like the man you had seen in the picture.
Yes.
Wait a minute, that's not what you said.
Watson, we don't want anybody in this courtroom in an undershirt. If he can go get a shirt, he can come by.
Sure.
Great procedure.
Yes. Did you ever say, or did you ever, you said here just a moment ago that you did not see profile? I understood you to say, is that correct?
Objection, that's not what you
In
said.
court?
Please stay consistent with your answer when you make procedure.
Could I have the answer read back?
Yes, you may.
Since I had that little interval.
Yeah, I can appreciate that. I think that's a valid procedure.
Answer, I didn't get the exact profile that I had gotten that night. I'd have recognized to look like the man I saw in the picture, but again, it was not that exact profile as I had seen in the picture.
So, if I understand, you previously remember stating to Mr. Minerva that the profile looked the same, but then I saw him face on and I couldn't recognize him?
Objection.
Ask her if she ever made that statement, and then you may reply.
The question was by Mr. Minerva, Mr. Bundy looks thinner than the person that you saw? Answer, yes. As I saw him in the courtroom, he looked awfully thin, but his height looked the same. The profile looked the same, and but then if I saw him face on, I couldn't recognize him. Do you recall that question and answer?
Yes, I do.
Is that correct? Is your answer there correct?
Yes.
So it would be fair to say from that that you couldn't recognize him in the courtroom?
Objection.
I think that's fine. Just stay.
would it be fair to say, Ms. Neary, that during the progress of this case, you've gained more confidence in your identification?
I think confidence might be a bad word. Restate the question, I'll let you ask it.
Well, you have gained a greater degree of emotional certitude.
Objection.
If you leave emotional and ask certainty, you may ask the question.
Emotional certainty?
No, I think I said leave emotional. You've gained a great deal more certainty of his identification. I'll let you ask the question.
Yes.
Would you say that that has been a gradual process?
No.
Has your original observation of the assailant been improved in any way by any of the procedures that you've been subjected to?
Objection.
Limited to hypnosis, I'll let you ask the question.
Has your ability or your observation of the assailant on the morning of January 15th been improved by hypnosis?
Objection. She's already answered that.
I'll let her answer that.
Has it been improved by the hypnosis?
Yes, ma'am.
No.
No. When you were under hypnosis with Mr. Arroyo, can you describe your visual representation that you had?
Objection.
I think she's going into the been testified to previously.
I was going to develop a different point now.
Well, I understand that, but she's already testified to it. Use that as an already established projection point. Proceed on.
Was the image that you held for Mr. Arroyo, how would you describe it? As clear or fuzzy?
I'll let her answer.
Or anything in between?
It's hard for me to answer that. The details were clear, but not any clearer than before.
Step up in the witness box and raise your right hand.
Do you solemnly swear that the testimony you will give the truth, whole truth, and nothing but the truth shall be the truth?
Please be seated. Would you state your name for us, please?
Karen Ann Chandler,
Spell your last name for the record.
Chandler.
And where are you from, Karen?
I'm presently in Atlanta,
Okay. And where did you live back in January of 1978?
in Tallahassee,
Where?
at the Kymega House,
And do you recall what room you lived in?
room number 8.
Did you have a roommate?
Yes, I did, Kathy Kleiner.
Okay. What was your major, Karen?
My major was fashion merchandising.
Okay. And what are you doing in Atlanta now?
I work for Riches.
Okay.
Do you recall the night of January the 14th of 1978?
Yes, sir.
Okay. What were you doing that night?
That was Friday night.
That was Saturday.
Oh, Saturday night. I had gone over to my parents' house to fix dinner for them, and I had come home kind of early.
Okay. Do your parents live in Tallahassee?
Yes, I do.
Okay. And whenever you say you came home early, where did you come to?
The sorority house.
Okay. How did you gain entry to the sorority house that night?
Through the back door.
Is that the combination locked door?
Right.
Okay. What did you do? What did you do when you came into the door? Came home.
I punched in the combination and entered.
Okay. What did you do whenever you came inside?
I walked through the rec room and up the stairs and into my room.
Was your roommate home at that time?
No, she wasn't.
About what time are we talking about now?
Between 10:30 and 11.
Okay. What did you do whenever you got to your room?
I started sewing and I was watching TV.
Okay. Did you go to bed?
I went to bed about 12 o'clock.
Okay. How about your roommate? What time did she come in, do you know?
She came in probably a little after 11:30.
And what did y'all do after she came in?
Well, she went right to bed. And I sat for a little while and then I turned off the TV and went to bed.
Okay. And did you hear any noises or were you aroused during the night?
No, sir.
What is the next thing that you remember?
Being lifted into the ambulance.
You recall that?
Mm-hmm.
Okay. What's the next thing that you remember after that?
Getting sick.
Where was that, if you know?
At the hospital.
How long were you at the hospital, Karen?
From that Saturday night until Friday afternoon of the next week.
Okay. Were you injured?
Yes, sir.
Could you tell us what your injuries were?
Well, I was hit at the head, and I had cuts on my head. I had a broken jaw. Some of my teeth were knocked out. I had broken facial bones. I had a broken arm and a crushed finger.
I'm sorry, I didn't hear the last name.
A crushed finger.
Karen, do you know who did that to you?
No, sir.
Were you awake or asleep at the time that it happened?
I was asleep.
Nothing further.
Mr. Harvey? Will this young lady be excused?
Yes, sir.
I think you're free to go, young lady. Who is your next witness, Mr.
Kathy Kleiner DeShields.
Come right over here, please, ma'am. Step up to the witness box. Let me correct this where you.
Raise your right hand, please. Do you solemnly swear that the testimony will be the truth, the truth, and the truth, so help you God? I do.
Be seated.
Would you state your name for us, please?
Kathy Kleiner DeShields.
And could you give us the area in Florida that you live in at this time?
Boca Raton.
All right. Where were you living back in January of 1978?
At the Chi Omega Sorority House,
And in what city is that?
Tallahassee, Florida.
How long did you live at the Chi Omega Sorority House?
Since September of '77.
Okay. Did you have a roommate?
Yes, I did. Karen Chandler.
Okay. Were you going to school at that time?
Yes, sir, I was.
And what was your major?
Interior design.
Okay. Are you finished with school now?
No, sir.
You're not?
Are you married?
Yes, sir, I am.
When did you get married?
June 79.
Kathy, do you remember the night of January 14th of 1978, Saturday night, or the early morning hours of January the 15th of 1978?
Yes, sir, I do.
What were you doing that Saturday night, if you would tell us?
I had gone to a wedding in the afternoon, and then I had gone over to my boyfriend's house with some friends. We had dinner, and then we went over to another couple's house and had just a little get-together. And then I went home back to the sorority around 11:15 that night and was in bed by 11:30.
Okay. Was your roommate there at that time?
Yes, sir.
Okay. Did both of you go to bed at the same time?
No, sir. She was sewing, and I got ready to go to bed, and she was watching a movie on TV. And she went to bed shortly after.
Did you go to sleep?
Yes, sir.
Did you hear any noises, or were you aroused that night?
I was awoken after I was attacked, and I remember commotion, but I didn't have my glasses on, and I don't remember anything that was going on, just a lot of commotion.
Could you tell us the first thing that you do remember?
Sorority sisters, I believe it was Jackie McGill and Nancy Dowdy, and I was asking for my pastor, Austin, and my boyfriend, David. Then I remember paramedics were being there.
Okay. Was this still at the sorority house?
Yes, sir, it was.
Okay. What's the next thing that you remember?
Being taken down the stairs on the stretcher and taken out into the ambulance.
Okay. Were you taken to the hospital?
I believe so. I don't remember anything else until I was in the hospital.
How long were you in the hospital?
About a week.
Could you tell us what injuries that you had at that time?
My jaw was broken in 3 places. I had lacerations on my shoulder and like whiplash on my neck.
Okay. Any problem with your teeth?
Yes, sir. I had, my teeth are still loose on the bottom, and I have a pin in my jaw.
Kathy, do you know who did this to you?
No, sir.
Nothing further.
May this young lady be excused. I think you're free to go, young lady.
Judge, this is a logical breaking point.
Are you going to have some time in the next one?
Well, it's a logical breaking point.
All right. All right.
It depends on the defense, Judge.
I'll employ your logic, Mr. Simpson. I had to kind of laugh. That young lady thought 1 month's marriage was like a year. Is that Take the jury out, Mr. Watson.
Course of intravenous saline that is used every day in the hospital, and I was satisfied that it was a satisfactory source.
Did you do any testing on it to make sure it was?
No, I did not.
Do you know who made the saline solution up?
Excuse me?
Do you know who actually made the saline solution up?
I would imagine that it was a pharmaceutical company because, to my recollection, it came from a bottle that had that was there for use as intravenous fluids.
So you didn't make it up at the lab?
I'm sorry, I can hardly hear you.
It was not made up at the lab?
Correct.
Where was the tissue kept?
I do not know where the tissue was kept.
It was not kept there at the lab?
It was not in my custody. I turned the tissue specimens over to the law enforcement people who were there at the autopsy, and I gave it directly to the Sergeant.
I'll show you exhibit number 32. You recognize that?
Yes.
Do you recognize the ruler that's in that picture?
Yes, I do.
Are you present when the picture depicted in exhibit number 32 was taken?
Yes.
And who took that picture?
It's my recollection that Sergeant Winkler took that picture.
And where did that ruler come from?
That is just like the standard rulers that we use in the morgue to do autopsies. And I'm not certain where this particular one came from, but it's very similar with the exception of color to one that we're using right now. And it's my presumption that it came from a scientific supply house.
All right. You don't know where that particular ruler came from?
Correct.
Do you know what happened to that particular ruler?
It was my understanding that the ruler was taken in evidence, or for evidence.
Let me ask you this. Did you hand the ruler to anybody?
I think that I handed it directly to Sergeant Winkler. I gave him, and also Deputy Kirkham, I believe, all of the evidence that I transmitted.
Do you remember whether or not you kept custody of that particular ruler?
I do not recall taking custody of that ruler.
Do you have custody of that ruler now?
No, I do not.
Now, you stated that it's similar to other rulers that you keep there in the pathology lab. Is that correct?
That's correct.
Is there a supply of them kept there?
I don't know how many we have. I've never failed to have one when I needed it.
Was that ruler, or could that ruler have been just returned to the other supply?
No, I'm going to sustain it. He doesn't know.
And where, you said it comes from some type of supply house, these type rulers do? Where do you get them from?
Objection to repetition.
I'll let him answer that.
I'm not certain where this particular ruler came from. I know that the rulers that we use in autopsies are available from scientific supply houses, but I'm not aware of the specific source of this particular ruler.
Now, you stated that you were present when the picture depicted in exhibit number 32 was taken. Is that correct?
Show me that picture to be certain, please. Yes.
All right. And you stated that Sergeant Winkler took the picture?
That's the best of my recollection, that Sergeant Winkler took the picture.
Did you assist in any way when the picture was taken?
Yes, I did.
All right. And can you remember how it was taken? In other words, was it taken from a handheld camera, or was it taken from a camera on a tripod, or in what manner?
My recollection is that this was taken from a handheld camera.
Do you recall how far away from the body the person was that took the picture?
I'm going to object to this.
I'll let him answer that.
No, I don't recall the exact distance. I think that he was fairly close.
Now, was the ruler that was used in the picture, do you know who positioned the ruler?
I may well have positioned the ruler myself because I assisted in the picture taking. As a matter of fact, some of the other pictures I actually had, I think my wristwatch, or maybe you could see the gloves that I had on or such. And I recall participating and helping with the pictures.
The ruler that was used, do you recall whether that is a thin plastic or a hard plastic ruler?
It's a hard plastic ruler, and it has a metric scale on one side and inches on the other edge.
If you recall, could you tell me whether the ruler was bent to conform with the body, or was it just laid on top of it?
Well, there was really very little bend in the body where that picture was taken.
My question was, do you remember holding it so that it bent with the contours of the body or not?
No, I don't remember that in detail.
Did you mark that ruler in any way?
No, I did not. At least I certainly don't recall marking the ruler.
And you don't remember having custody of it after this was done?
No, I told you a little while ago that it was my recollection that Sergeant Winkler had custody of the ruler, and I do not have custody and did not have custody, to my recollection.
Do you recall whether or not that was the only picture taken of the bite mark with the ruler in it?
No, I don't recall.
Tom, may I have a moment?
Yes, sir.
Did you weigh the tissue that you excised from of the bite mark on the left buttock of Lisa Lee?
No.
Would it then be impossible at this point to tell whether the tissue either shrunk or became more swollen?
Objection.
Did you measure the tissue that you excised?
No, I widely excised the bite mark, and I took a fairly wide margin around it, and also went very deeply. And I did not record the exact measurements of the piece of tissue.
All right. If the piece of tissue were measured at this time, would it be possible to tell a difference if there was such a difference in the measurements?
Objection.
Sustained.
Do you have custody of the tissue?
No.
Who did you give the tissue to?
Objection. He's answered that 3 times.
Sergeant Winkler, Mr. Hart.
What was the purpose again of putting the tissue in the saline solution?
Objection. He's testified to that.
Testified to.
All right. You stated before that the purpose was in order that it wouldn't shrink or swell. Is that true?
That's what I stated previously.
All right. How would you go about measuring whether it shrank or swelled later?
Objection.
Sustained.
Was the purpose to keep it from shrinking or swelling, to keep the tissue in essentially the same or similar condition as it was when it was excised?
Objection.
I'll let him answer
Well, yes, my purpose was that I wanted the tissue preserved in such a fashion that if it were possible at a future date to relate these bite marks to a probable suspect, that could be done. And that was my purpose in removing the large block of tissue that included the teeth marks, because at that time I was aware that this might be a very real possibility that through these teeth marks later a suspect could be identified or a possible suspect.
Doctor, have you seen this tissue since you excised it?
Yes, I have.
When is the last time you've seen the tissue?
I don't have the exact date in my notes. I've seen the tissue at least twice, and I think possibly 3 times since the day of the autopsy.
And it has shrunk, hasn't it?
Well, you see, the tissue had been taken.
Doctor, I'm just asking, has it shrunk?
John, let the witness answer
You
the
may
question.
answer yes or no and then explain if he wants to.
The last time I saw the tissue, it had shrunk. It was shrunken because it had been later put in formalin. And the reason it had been put in formalin so that it could be preserved. However, it's my understanding that initially it was kept in saline and it was not placed in formalin initially, but kept in saline under refrigeration.
Doctor, did you put it in formalin?
No, I did not. I did put fresh formalin in it.
I would move to strike the testimony.
John, would Mr. Harvey let the witness answer the question?
If he doesn't, the court will. Go ahead and complete your answer.
The tissue was brought back with the possibility of further examination, that is, making histologic sections or microscopic slides of this area that can be studied. Eventually, it was necessary to place it in a formalin solution so as to preserve it, and proper fixation would occur so that the tissue sections could be processed. The tissue sections could not have been processed if it had been kept forever in saline. So later on, it was placed, after further observations were made, it was placed in a formalin solution and preserved, and then tissue sections were processed from the bite area.
Doctor, further questions?
Doctor, what I was going to ask you is, do you know when it was put in the formalin?
No, I do not know when it was put in formalin. It was put in formalin after it left my hands and before I got it back.
And when did you get it back?
Yeah, report.
No, it's in the other room. I don't have it in here.
His report's over in the other room. You want the answer to that question?
I would like to answer that.
All right. You may go get it. Doctor. A little bit rest while he goes get it. All right, Mr. Harvey, the doctor's turn.
Reporter, read back the question to the doctor.
When was it placed in formalin, or when did he receive it back, was the last question.
I first received it back sometime around May the 24th, 1978. The next time was May the 8th, 1979, and then there was another time since May the 8th that I have had occasion to see the specimen.
When you received it back the first time, was it in formalin at that point?
Yes, I recall that it was in formalin at that time.
All right. Have you got any measurements on the fluid exchange between the saline solution and the tissue?
I don't understand your question.
On the exchange whether the tissue absorbed the saline, how much it absorbed the saline, etc.?
Your question is still not clear to me.
His question is, did the tissue have any change of structure during a period of time that it wasn't saline? Is that it, Mr. Harvey?
That's it, Judge. Thank you.
I thought that's what it was.
All right, well, I did not see the tissue. I gave it to Sergeant Winkler in saline. When I saw it again, to my recollection, it was in formalin solution at that time. So if I did not add the formalin to it, I could not observe what happened while it was in saline.
So the answer is you don't have any measurement of that. You don't know.
Correct. I did not make any measurements at all.
It was a roundabout explanation to come back to that. I think that was fair observation, Mr. Simpson.
Thank you, Judge.
You have any redirect?
No, Your Honor.
Gentlemen, may the doctor be excused.
Yes, sir.
I think you're free to go back to Tallahassee, Doctor. Thank you very much. You have other witnesses, or you want to proceed on the other matter at this time?
We need to proceed on the other matter, Judge.
All right, take the jury out, Mr. Watson.
Yes, sir. Ladies and gentlemen, the jury, please retire to the jury room.
All right, gentlemen, on your motion for the inclusion of matters seized in Granger, Utah, let me hear your argument on the motion.
Relevancy, or? We've already had a ruling of suppression, is that correct?
On the suppression.
Judge, I believe we've raised the objection. I think it's the state's burden at this point.
I think that you're correct, and I was sort of looking for the state to jump up. But
State's up. Judge, I don't know if before we hear argument, the court might want to actually view the Utah pantyhose mask. We have introduced a photograph of it, but we have it right across the hall if the court.
that is all the court has seen is a photograph, and I am quite concerned with the view and quite concerned with some other testimony before I consider it. I'm not going to suggest what testimony I want, but I am going to say to you that the item itself certainly would be of some concern to the court in arriving at a solution.
Okay. In that case, we'd call Bill Gunner to come across the hall first with the pantyhose itself. Bill Gunner to bring the pantyhose.
Will you swear this witness?
Swear him on a motion, Madam Clerk.
Stand up, please, and raise your right hand.
I do.
You see these, please, sir?
State your full name, please, sir.
William P. Gunter,
Your occupation.
Deputy Sheriff, Leon County,
How long?
7.5 years.
During the course of your duties, have you had occasion to investigate certain portions of the case of the state of Florida versus Theodore Robert Bundy?
Yes, sir, I have.
In the course of your duties, have you had occasion to come into possession of a Utah pantyhose mask?
Yes, sir.
Who did you receive that mask from?
Sergeant Ben Forbes.
And roughly when did you receive it, if you recall?
It was last July, please.
78?
Yes, sir.
And have you brought that item to court today?
Yes, sir.
Has it been in your custody and control ever since that time you received it from Forbes?
No, sir. It was turned over to Dale Newt of the Florida Department of Law Enforcement, and I received it back from him.
Okay. You want to mark it for the motion? Okay.
Identification.
ID for the motion. She's got a motion list and a trial list.
And one thing for identification on the motion.
Show you what's been marked as State's Exhibit number 1J for identification on the motion. Ask you if you can identify that.
Yes, sir, I can.
All right. Open it up. Make sure you can.
Yes, sir.
All right. What do you find that to be?
This is the pantyhose that I received from Sergeant Ben Forbes last year.
And how do you recognize it? Got your initials on it or something?
Yes, sir. This is the bag in which I received it in, and it was kept in my possession and sealed. I in turn turned it over to Dale Newt, Department of Law Enforcement, and on 25 June '79 this year, I received it back from him in this same bag.
Been in your custody and control ever since?
Yes, sir.
Till today?
Till today.
That's all I have of this witness.
Any cross?
Judge, for purposes of this motion, excuse me. Can we view it, Judge, first? Can we view the mask first?
Yeah.
Any other questions for the motion?
That's all I have of this witness.
All right. Yes. Witness be excused.
Yes, sir.
Look at
Time being, Court.
the exhibit instruction.
Ben Forbes.
Let me see that photograph. The photograph. Okay.
I'm not over here. Please step right up in the witness box. Raise your right hand.
Do you solemnly swear that the testimony you give the truth, whole truth, and nothing but the truth, so help you
I do. Be seated, please.
State your full name, please, sir.
Benjamin Forbes,
Your occupation.
Deputy Sheriff for Salt Lake County, State of Utah,
How long have you been so employed?
17 years.
Do you recall a case in Utah in which you investigated the state of Utah versus Theodore Robert Bundy?
Yes, sir, I do.
Do you recall roughly the approximate date that case existed, was pending in Utah?
It started around August of 1975.
Did there come a time or an occasion when you came into possession of part of the evidence in that case?
Yes, I did.
Specifically referring to a pantyhose mask?
Yes.
Do you recall when you first saw that piece of evidence?
I believe that was shortly after the arrest of Mr. Bundy on possession of burglar tools in our state.
In August of '75?
Yes.
All right. Do you recall where it was that you first saw it?
On the 9th floor, which is the detective division floor in our office.
And where is the evidence locker at the station there?
It's on the 2nd floor.
And referring now to State's Exhibit 1B for identification, I guess, which has been remarked from 1J.
Yeah, it is 1B now on the motion. Let the record so reflect.
Ask if you recognize that exhibit. You can take it out if you need to.
It appears to be the same pantyhose that Detective Andre was in possession of when I first saw it.
All right, Detective Ondrak was first in possession of it when you saw it?
When I first saw it, yes.
Okay. Do you recall seeing it after that case in 75 went to court?
Yes.
When was the next time after that case was disposed of that you saw it?
That was 1978, I believe.
Do you recall Bill Gunner from the Leon County Sheriff's Office coming to Utah? Or
No, I don't.
do you recall coming to Tallahassee and meeting with Bill Gunner in Leon County?
I remember coming to Tallahassee, yes.
Okay. And was that in July of 78?
Yes.
And why did you come to Tallahassee?
To appear before the grand jury.
And did you bring anything with you?
I brought this pantyhose mask.
And is it in substantially the same condition today as when you saw it in 75?
It appears to be, yes.
And what did you do when you arrived in Tallahassee with it?
I just turned it over to Mr. Gunner.
All right. Does it appear today in the same condition as when you turned it over to Mr. Gunner?
Yes.
That's all I have this week.
Sergeant, that pantyhose mask in Utah was never introduced into evidence in any court action in Utah, was it?
No, sir, it was not.
No question. That's all I have.
This witness be excused.
Yes, sir.
Please go.
Daryl Ondrak.
Right this way, please. Do you necessary to re-swear this witness? Step up to the witness box, please, and raise your right hand. You be seated, sir.
State your full name, please, sir.
Darrell M. Undruck,
Your occupation.
Deputy Sheriff, Salt Lake County Sheriff's Office.
You are the same Deputy Ondrak who testified earlier on a previous motion in this case?
Yes, sir.
All right. In your testimony, or if you'll recall, you testified, and I believe we showed you a photograph of a Utah pantyhose mask you came into possession of in 1975.
That's true.
Recall that? Show you what's been marked as State's Exhibit number 1B for identification on the motion. Ask if you recognize that exhibit.
Yes, sir.
You can take it out if you need to. When you were in possession of that, what do you recognize that exhibit to be?
Pair of pantyhose.
Okay, the same pair we were talking about in 75?
Yes, sir.
Does it bear any markings, any initials of yours on it?
Yes, sir.
Does that mask or pantyhose appear to be in the same condition today as when you first saw it in August of 1975?
Other than these other initials that are on there, yes, sir.
No substantial or material differences in it whatsoever?
None that I can see, sir.
Move it into evidence, Judge, on the motion.
On the motion. Received on the motion.
That's all I have of this witness.
All right. I think you're free to go, sir. Thank you.
That's all the testimony we have on the motion, Judge.
All right. Let me hear your argument on the motion.
Factually, Judge, our argument is fairly obvious. You've heard now testimony in the trial regarding the various pantyhose ligatures which in the state's opinion are similar to this one, which is also a Hanes pantyhose, similar knots, and similar loops in the end of it. But factually, we would suggest that there is, but for the remoteness in time, every similarity between not only the murder weapons we found in our cases at Calmega, but also the pantyhose found at Dunwoody. There's a similarity in the knots. There's a similarity in the eye holes. And of course, if the court would allow us, and I'm sure that Florida law and U.S. law would not allow us, we could explain why the remoteness exists. Mr. Bundy has not been out on the streets, of course, since 1975. But our chief case that we've cited to the court is the more recent Williams case in 71.
You view this as a Williams situation?
It's not really, and that's a point I need to raise probably first. It's not a similar crime we're asking the court to allow in this trial.
What is the probability of it?
Well, the defense in this case, as best as we can tell, is identification. In both the Calmega and the Dunwoody cases, they say we got the wrong guy. The evidence we have is except for Nita Neary, circumstantial, as circumstantial evidence can be. It is a combination of links in the chain, as it were, and the hair from Mr. Bundy's head is similar to or highly likely to be the hair we found in the pantyhose mask at Dunwoody.
Now, I understand the representation to the court there is that hair from Bundy is similar to, okay.
His possession of this very similar pantyhose mask goes directly to the issue of identification, and that is the only purpose the state is trying to use it for.
Well, you view the same law applicable to that as to Williams?
No, not exactly. We feel like...
well, you put the court on about a 4-day tangent looking for Williams.
Well, we don't need to be on that tangent. It's a two-pronged thing, much like the statements were. There's the relevancy situation, and then there's the admissibility situation. And we feel like...
And the remoteness situation.
And the remoteness. We feel like we need to argue all the points so that the appellate court understands we weren't blind to something.
I'm going to say to you clearly and unequivocally, grab your best hope, because I'm going to start pinning you down in a few minutes.
As I say, Judge, really the only thing that we feel that is questionable as a matter of law in it is the remoteness of it and the possibility that the testimony about his crimes in Utah would come out. Now, we can guard against those crimes in Utah coming out if that's a problem for the court.
All right. Any response from the defendant?
Judge, the argument on this issue is similar to the issue because the test is relevance. And what really is the relevance issue? Only similarity between the two masks is that they are pantyhose masks. That's the only similarity. There's no similarity in the knots, the way they're made, the number of holes. But beyond that, the mask that's found in Utah is not connected with any crime. The finding of Mr. Bundy's possession of it was in a car search. There's no link to any burglary or to any murder in Utah. It's remote. It's 4 years ago.
Mr. Harvey, there is no question in this court's mind that it is connected to a crime, the pantyhose in Utah. I have no question of that in my mind, because they had nothing but mere possession.
You have
And the possession, no, I don't have any question about that. The possession of it per se is not a crime, is it?
No, sir. And that's, there is no criminal.
That's why the court is concerned with the labor that's been expended toward the application of Williams.
Well, Judge, the labor that's been expended is because of the very obvious effect, prejudicial effect that its introduction into evidence would have.
No question about that.
And I've been trying to figure out what the state is trying to do other than show a propensity of Mr. Bundy to carry around pantyhose.
Now, you and I know if it went to propensity, it's clearly outlawed.
Well, that's our position.
I don't think you got to argue that even to this court.
All right, that's what I was about to argue, but if I don't have to, I won't.
No, I think that's very clear from the Williams Rule's decision that it can't be shown for a mere propensity to commit crime. And I can't see where the possession of pantyhose, if it is, we'd probably have to put every lady in this courtroom in jail.
Yes. Now, Judge, I would ask that the court, if the court is worried about whether or not they are similar in type or make or the way the knots are.
I have a rather fairly comprehensive decision of the Hanes pantyhose that was Hanes Alive size D, I guess, whatever that means. They were inside out with the right leg cut out, split down the side on the waist back and a knot in the left leg, leaving a loop. You find any similarity between that and this, Mr. McKeever?
Well, has the court held this one up and looked at it in the same fashion? I do find similarity with it.
Oh.
It isn't cut up the same way.
I'd like to hear you.
Let me see if I can draw an analogy between this situation. All we're offering this item as is a piece of circumstantial evidence. We're not offering it as positively an element of the crime or anything. The court understands that.
You're getting close now, you know that, don't you?
Well, I know that. And it's not unlike a situation where a man is charged with embezzlement. And during that embezzlement trial, part of the evidence established is that he has a Swiss bank account. We are trying to prove in a different situation, a different case altogether, that he had a Swiss bank account. And if we don't talk about the embezzlement situation at all, it's fine with the state. All we would like this jury to be aware of is that the man has had a pantyhose mask in his possession in the past, very similar to the one that he is charged with having his hair in this case. And but for the remoteness, there is no problem. Now, we can solve that remoteness with testimony.
Mr. McKeever, the court's question on the matter is, would there be such a sufficient standing of similarity or dissimilarity to impact any concept of uniqueness that might come from the possession of such a right?
I'm not sure I follow.
Well, what if we are going to admit a related circumstance sometime remote prior to the commission or the alleged commission of any offense or the charge? There need be some kind of concept of uniqueness of the particular thing. We couldn't introduce that in 1975 he was breathing or anything like that, could we?
No, sir.
But that's where the court is headed, and I'm concerned, and I want to know your response on it.
Judge, our argument is that that is a very unique thing to have in your possession, and that is exactly our point. That pantyhose mask is extremely unique. People just don't carry pantyhose masks around with them with a knot.
What say the defense to that, Mr. Hart?
Judge, the whole point of this is that if this court puts the Utah pantyhose mask into evidence in this case, it's going to be the only piece of evidence in which anybody can point and say Mr. Bundy had anything. It would be a totally collateral issue of whether or not he possessed a pantyhose mask in a strictly legal sense. And yet, it would be drug into the Dunwoody Street crime, which has absolutely no other identification towards Mr. Bundy. All right? And it's going to be used for the state by a backdoor method of getting into the terminated crime. Now, the prejudicial effect of showing possession of a pantyhose mask to Mr. Bundy 4 years ago would create a side issue that would become a feature of the trial, number one.
But is it 4 years ago?
Is it 4 years ago?
It was from August to January, past 2 years, wasn't it?
It was in August of 1975.
All right, now this offense occurred January of 78, didn't it?
All right, Judge.
So that's 2 years, and from August to January. I don't have my fingers out. I can't count that real quick. How long is that?
I was thinking about it right now, Judge.
All right.
Whether it's 2 years or 4 years, remoteness is part of the issue. The other part of the issue is...
I found some cases that went to past 4 years that were admitted, Mr.
Judge, the remoteness is not the only issue.
All right.
It's the probative value of possession of a pantyhose mask. And it's whether or not, in this case, you can show enough similarities. And when you look at the similarities, you not only have to look at the physical way the mask is put together, which is totally dissimilar in terms of the number of holes, the type of pantyhose that is used, but also there has to be some testimony as to what or how, what unique manner of use the pantyhose was put to in Utah. And we have no testimony as to that. The only testimony we have is it was in his car. And Judge, the prejudicial value in this case would be bringing in a collateral...
That is the very core of what we're addressing ourselves to, gentlemen. Does the probative inference outweigh the prejudicial value? And that precisely is the question that is before the court. And the prejudicial concept is very clear. Of course, every evidence that is not, any evidence that is not exculpatory or points to the defendant is prejudicial to him. The court finds no sacrosanctness in that argument, but the point that concerns the court is just that. Is the probative value of such significance that it outweighs the prejudicial value to the defendant? For I don't find this to be a Williams rule matter, primarily or per se. The only link between the identification of Williams and this would be toward identity. But we don't have a similar fact occurrence or a similar fact crime. What we have is a circumstance that existed, that was known to exist in 1975, that might or might not be germane to the issues that are before the court. Now, there's one more thing I want to hear from counsel. I didn't mean for you to sit down so quick. And that is this. Let us take the two crimes, Kaimega and the Dunwoody, and let me hear your respective impact of probality to those crimes or as they are alleged. You see any distinction between the two?
Our intention would be to argue just as to Kaimega that it's similar to the murder weapons, the strangulation pantyhose there. So we would fully intend to use it at Kaimega for the relevancy of the possession of a similar type murder weapon. They not slip just as surely as they slipped on Margaret Bowman's neck. And not only are the eye holes unique and significant, but the knot is unique and significant.
Were there eye holes
in Utah?
Yes, sir.
And in Dunwoody?
Kaimega?
No. The knot.
See, that's the court's question.
Well, we're not as strongly concerned about the Kaimega use of it. If the eye holes only go to Dunwoody, then the jury can be so instructed. But we feel that the knot, in conjunction with the eye holes, make it relevant to both cases.
Defense respond to that, or desire to?
I believe it's important that the court take a look at both pantyhose masks and see if those knots slip, because as my understanding, those knots, neither one of them, in either one of the pantyhose masks, are tied in such a way that they could be used as ligature. So I think their argument as to the connection between Kaimega and Dunwoody is totally unfounded. Would the court want to view the two pantyhose masks?
I'm kind of prone to agree with you. I don't think the matter's got any application to Kaimega.
All right. Then we'll just move it into evidence on Dunwoody, Judge.
Well, it is a circumstance, and let me say that the court has labored with this probably as much as any challenge brought forth in this case thus far.
Judge, I think I need to make another point.
I want to hear you. I need all the help I can get.